Wheeling collected them for us and sent them to us. We're gonna admit about 5 or 6 of them. And Mr. Thierry, I didn't wanna call Detective Wheelan just to say they were located in his vehicle. So I believe Mr. Thierry's agreeing that.
At what point would you like me to read this?
When I enter that exhibit into evidence.
You just turn and remind me that you're about to do
Sure.
it, and I'll read this instruction.
Okay.
Very good. Anything else? State, are you ready to proceed?
We are just, we've rested, so.
Right, I mean, just in general.
Yes, in general.
And the defense?
Yes, Judge, I just wanted to let you know, because of a lot of things you've heard we're not getting into, obviously, I might have to take a very quick, minute or two before, if certain witnesses come in, to remind them. So if I indulge the court, may I have a minute? You know what I'm
Absolutely.
doing. Thank you.
All right. You can bring them in. Make sure this is on. And is somebody going to be working on the changes to the jury?
Ms. Tucker is.
Oh, very good, thank you. Team effort. What's up? I just be able to make sure we go over the. I don't think this will play much of it now. I don't know. I'm stuck at 6 o'clock in the morning. for the jurors. Jury's back, y'all may be seated. Welcome back, ladies and gentlemen. I assume, this is always dangerous, but I assume that there were no issues with the court's instructions. No one spoke to you about the case. You didn't speak with anyone, no TV, no media, nothing of that sort.
No, sir.
All right, very good. You may begin whenever you're ready.
Thank you, Judge. The defense at this time will call Emma Hamilton to the stand.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Whenever you're ready, Counselor.
Thank you, Judge. When you're ready, could you let the jury know your name, please?
My name is Emma Hamilton, Hamilton.
And Miss Hamilton, what is your date of birth?
11/23/1956.
And how old are you at this time?
68.
68? Okay. And are you presently employed?
No, not now.
Okay. And do you live in Tampa?
Yes,
Okay. How many children do you have?
6.
6. All right. I want to kind of ask you about your children. We've heard a lot of names of people. First of all, tell us the name. I know, do you have 3 sons?
Yes,
And do you have 3 daughters?
yes.
All right. Go ahead and tell the jury the names of your sons, if you would, please.
John Stallworth, Antoine Stallworth, and Ronny Walker.
Okay. And do you know where John Stallworth is today?
No, I don't.
Okay. Are his whereabouts unknown?
I haven't seen him in a minute now, so that's all I can
Okay.
say.
That's all right. You haven't seen him in,
I haven't seen him in almost a year now.
all right. Antoine, where is Antoine presently?
He's incarcerated.
All right. And Ronny Walker, do you see your son in the courtroom?
Yes,
All right. And is that your son sitting at the defense table with Miss Bradley and Miss Schlemmer?
yes.
Oh. Miss Bradley and Miss Dunker. All righty. How old is Ronny right now?
46.
Okay. All right. And do you have a relationship with your son, Ronny Walker?
Yes.
All right. Now tell the jury the names of your daughters, please.
Tanya Jackson. I'm just so nervous. Paula Hardy and Nakisha Grace.
Okay. Can you spell Nakisha for the court reporter for me?
It's Nakhis, I think that's how I spell it.
All right. And because we've also heard some other names, just give me an idea, how many siblings do you have?
Well, it was 7, but it's only 5 left.
Okay. All right. Are you included in that 5?
Yes.
Or you, okay.
Yeah.
All right. Can you give us the names of your brothers and sisters?
Johnny Frank Hamilton. These the boys. Will Hamilton and Sandy Hamilton, and my sister Johnny Mae Matthews.
Okay. And 2 of your siblings have passed on?
Yes.
Okay. All right. Now tell the jury, who is Ronny Walker's father?
Larry Walker.
All right. Now tell the jury, has Ronny Walker ever had a relationship with Larry Walker?
No.
Tell us the circumstances why that is.
Well, I was like 8 months pregnant. He left, and I ain't seen him since.
Okay.
Been over some years, 20 years, 30.
Okay.
I haven't seen him, but I talked to him.
All right. So you were 8 months pregnant, was that with Ronnie?
Yes,
Okay. So when you were 8 months pregnant with Ronnie, Larry Walker took off.
yes,
To your knowledge, has Ronnie Walker, your son, ever met his dad, Larry?
no,
Do you know, Miss Hamilton, whether never knowing his father, being abandoned by his father, has affected Ronnie?
yes, because he never had a father in his life.
And did you raise Ronnie alone until he was 10?
Yes,
Okay, we'll talk more about that. Was Ronnie born in Tampa?
yes,
Okay. All right. Let's talk a little bit. You had mentioned you were 8 months pregnant with Ronnie when Larry took off. Did you have prenatal care when you were pregnant with Ronnie?
yes.
What type of care did you have?
I was always sick. I was carrying him.
Okay, so you were sick?
Yes,
Okay. Did you go to like regular checkups to the doctor while you were pregnant with Ronnie?
yes.
Did they know why you were sick?
No, they just sick in the stomach all the time.
Okay. Speak up just a little bit.
I was
Trail
sick in
off
my
a little.
stomach all the time because I carried him so low.
Okay. All right. Is Larry Walker the father of your other children?
No,
Okay. Is Larry Walker the father of any of your children?
no,
Just Ronnie.
just Ronnie.
Mr. Walker. Okay. Now tell the jury a little bit. When Ronnie was born, and up to about 6 months, was he constantly sick?
Yes, he was born sick. He had pneumonia, double pneumonia,
When did he have double pneumonia?
when he was born.
Okay. And did he also have like bronchitis at the time with
Yeah.
the double pneumonia?
Yes,
And was he in the hospital for that?
yes.
Okay. And do you remember about how old he was at the time?
Well, he went in when he was a baby. He stayed in for like 3 months, 4 months. He came home, but he got back sick again. So I had to take him back to the hospital. He stayed in like a month. Came back. About 2 months later, he started having seizures.
That's what I wanted to ask you about. Does in fact your son Ronnie Walker suffer from seizures?
Yes,
Right. So did the seizures start after the hospitalization for the double pneumonia?
yeah, after.
Okay, after that, right. So then, Miss Hamilton, did he start having seizures then when he was under the age of 1?
Yeah, he was like one, like someone longer than
Right
me.
about 1 year of age?
When he started, yes.
Okay. All right. Can you describe, I'm sure the jury knows what seizures are, but describe what would happen when Ronnie would have seizures when he was young?
He'd just pass out shaking real bad. I didn't know what it was because I was very young. So, I had my sister, my mother around, but my sister know what it was because she was older. And we took him to St. Joseph Hospital, and that's where they kept him at for overnight observation. Brought him back home. By the time we got him back home, he had like 2 more. So my sister already know what it was, so we didn't take him back. After that, he just studied, had him like up until he got like kind of grown. But mostly he always had him like, he had to always stay in the house. He'd go outside and play with some of the kids, but he would always fall out. Kids go to running because they didn't know what it was because he was shaking so bad. And he hit his head.
Yeah, tell the jury about that. What do you remember, Miss Hamilton, about seizures causing Ronnie to have head injuries? Tell the jury about that.
He fell a lot. He fell out the window, like 2 stories. But his head more like hit the ground, but his body hit the cement. He was riding up something like a little bike thing, ran into a pole, into a curve, bust his head open, skin his legs up. He's always falling, always.
When you say he ran into a pole, did the pole hit his head or another part of his body?
No, his head, bust his head open here, up here.
Tell us a little more, what kind of window did he fall out of?
I guess I stayed in the project. They had you had to wind the windows out on both sides. So they was up there playing in their room, him and his brother, playing football, you know, 'cause I let them stay in the house sometime, you know. I guess when he was going at it, he just went out the window and fell. After that, I took him to the hospital. They said
Go ahead, sir.
they said he was okay, so.
Okay. And this is sometime before he turned the age of 10 and went to live with Gloria?
Yes.
Okay. Can you recount about how many times a seizure caused some sort of head injury?
Oh, just about every seizure he had growing up, he had injury. You know, he got his leg cut, you know, just falling on like cement, 'cause where I stayed there was a lot of like cement. Like, then you got dirt around the house, but when they go out in the street, it's like pavement up. They got the old curves there. And he always fall. Somebody come and get me, tell me he done fell and bust his head open and he bleeding, and, you know.
When he fell out the window, you indicated, did you take him to the hospital?
Oh, yes.
Okay. Do you remember what hospital? I know it's been a long time.
St. Joseph. That's where I always went because I was closer to my house.
Did you say Suncoast?
St. Joseph.
Oh, St. Joseph. Okay. All right. Did Ronny get medication for his seizures when he was a child?
Yes.
Okay. So tell the jury a little bit about that. If you remember who prescribed them and what they were, if you remember.
They sent me to the University Hospital. That's where he was going to get tests done on his head to see what kind of seizures he was having. And then they described some of it, but I can't think what it was. It's been so long. But they did give some. It slowed it down just a little bit, but not that much. So I just kept giving him the medicine every morning, but he still had seizures. They'll turn into like a light seizure. They had broke it down. He'll just look at you, won't say nothing, but his eyes will turn real red. But they told me it was okay, as long as he was sitting down. He'd sit down, but when he get up, he just shake a little bit. And I was doing that day, you know. But just about every other day, he'll have some like a little minor seizure sitting there.
And is this like, I know at the age of 10 he goes to live with Gloria. We'll talk about that in a minute, but are you witnessing these seizures in the first 10 years then of his life when he's living with you?
Yes.
Okay. All right, so did you try to keep your son Ronny Walker on his medication during that time?
Yes, he had to take it like every day.
Did it appear to help him when he was a child?
They didn't want to like give him a bigger dose until they really found out what kind of seizures it was. They knew it was like they trying to grandmother seizures, stuff like that. That's why they didn't give him a higher dose, but they said to slow it down, but not that much until they do whatever they had to do on his head.
Okay. Does Ronny presently, does he stutter sometimes?
When,
His speech?
yeah, now he do when he fail.
Oh, he what?
He didn't used to study.
Okay.
No.
All right. And tell the jury a little bit, his developmental milestones, like him growing up. Was his speech delayed when he was a child?
Yeah, it came from the seizures. By he hitting his head so much, and they said his pupils was so far that it was hard for him to like really come back in. After that, I think they said the last fall he had probably did some of his speech, probably be his learning, slow him down a little bit.
Did he have trouble learning?
Yes.
Okay. Did he have trouble in school learning?
Yes, he went to a speech therapy.
Okay. Did he go to multiple schools when he was living with you?
No.
No? Okay. Did he go to different schools when he was living with Gloria?
Yes.
Okay. Do you know, and only if you know, whether the school system up to the age of 10, when he's living with you, were doing things for him at school for his delays?
Well,
If you know.
back then, they didn't really have a lot of stuff like they have now. You know, you can't put your kids in like a special class. He had to be there with everybody else. So they didn't have time to like just teach one kid. So he did the best way he could in school, and you know, that was it.
And this would have been like in the 70s,
Yes.
right? Okay. Okay. Now, tell the jury a little bit about the area you lived in with Ronnie up to the age of 10. What kind of area did you guys live in?
It was okay because I lived way down in the, like I call the bottom. I didn't live up front where the bars and stuff were. I lived in the project, so it wasn't really nothing going on around there. You know, you see people, you don't see them, or they sitting on their foot with more like older people. Where I stayed at, you know, I never stayed up front, and it wasn't.
You never stayed what?
Like up front, like in the neighborhood. I stayed in the back, you know, so just like in the project, just like in a little circle there. A lot of older people.
Did you say in the projects?
Mm-hmm.
What do you mean by that?
That was the name, like West Tampa.
Okay.
I stayed in the project.
Do you know, why do they call it the projects?
For low incomes.
Oh, okay, gotcha. All right. Okay. So, were you raising Ronnie and all of his siblings alone before the age of 10?
Yes.
Right. How did you support yourself and all the children?
I worked and just got food stamps.
When he was younger, and we're still up to the age of 10, was Ronnie close to his siblings and his cousins and his family?
Yes.
All right, let's turn your attention to about 10 years of age. And I want to talk to you about when Ronnie was sent to live with Gloria. So when Ronnie turned about 10 years of age, did something happen to where your children no longer lived with you?
Yes, the last seizure that Ronnie had was real bad. I was working and I didn't have no car. I was young. I had to take him to the university. And I didn't have no way to get there. About a week later, the HRS people was at my house because of that one mistake. And at that time, I didn't have anybody to help me. I didn't know who to go to or trying to get a ride, you know, because where I stayed, it was old people, you know. My sister and them stayed in other areas and stuff like that. So, you know, everybody was on their own doing what they had to do, so.
You were on your own during all this time?
Right.
Okay. So you had mentioned HRS. Is it your memory that Health and Rehabilitative Services, now called DCF, was involved with the family because of that?
Yes.
Okay. All right, so what happened? Did you lose custody of Ronnie? Did you send him to live with somebody? What happened?
Well, when all this was happening, I asked my sister, because I seen, you know, they was coming to my house, sit like 4 hours a day with me. I didn't know, you know, I just let them come. And I don't know if I can't remember. I don't know if I did it at home or I came downtown, but I think I did. And I told the judge I didn't want my kids to be separated. Because I love my kids. I ain't had nobody to help me.
And you did the best you could to take care of Ronnie and his siblings, right?
Yes, and I asked my sister.
Now let's talk about that. So what sister are you speaking of?
Gloria Mason.
Gloria Mason. And is Gloria alive today?
No, she deceased.
Okay. All right, so tell us a little bit. You've described for the jury where Ronnie lived up to the age of 10 with you. Tell the jury a little bit about Gloria's environments for Ronnie. Mr. Walker.
Bad area. Oh, it was real bad where she stayed at because it was drugs all around. no matter which way you went, you ran into drugs. And they stay on the streets all night. They just sit on porches. They ain't care where they was. That's where my kids was, around that environment. So I ain't had no other choice, but she had to stay. They had to stay there. When she moved to another area, it was worse. So that's all my kids them around with drugs and her husband. So I ain't want my kid to go in the system at all. So I had to let them stay there.
So you said you didn't want your children going to the system, so that's why you had to leave them with Gloria, despite the environment?
Until I do what they wanted me to do.
Sure.
And
Did you have to do some things?
I had to do parenting.
Okay.
And really that's all I had to do, parenting and cooking. You know, because I didn't know how to cook that good, but I cook, you know.
All right, so let's talk about all the siblings then at this point. Does Ronny Walker, your son, go to live with Gloria?
Yes.
Miss Mason, all right. What happens to your sons Antoine and John?
They was there too.
Do they go with Gloria?
Yes.
All right. Tell us about Paulette. Where does Paulette go?
Paulette went with her father. You know, she could have stayed with my sister, but I just let her with her dad because she was closer to him. She always liked to be around her dad. So he'll bring her around on the weekend to see them, you know, and he'll take her back home.
Tell us about your daughter Tanya, or Tangi. What happened to her at this point?
Well, Ronnie was 4, she was 3. Her daddy came on the weekend, on a Friday, asked me can he take her for that weekend and he'll bring her back that Monday. It never happened. She I just met my daughter out of 41 years. She was gone, never in my life. Never seen how she came up, never how she went to school, but I always prayed and asked God to protect her while she was out. Because I said, no, one day I know I see my daughter again. And 41 years I met her 2 years ago.
Is that the same with Ronnie then?
Yes.
Okay. So now, Tangi, or Tanya Hamilton, she was actually then taken by her father when Ronnie was younger, before the age of 10.
Yes.
Okay. All right. And then Paulette is taken by her father when Ronnie is 10, and Ronnie goes to live with his brothers with Gloria.
Yes.
Okay. All right. Did you visit the home where Gloria lived?
Yes.
Okay. How many times could you visit?
Well, I could go there anytime I got ready, but I had to get a second job because they started taking my first check. So I had to go get another job. I told her, you know, you can keep that first check, but I always like to buy my kids clothes, whatever they wanted. So I had to get a second job to take care of them because I feel that was my responsibility. Even though she had them, I told her she can get the food stamps, I ain't care. But I had to go get a second job. After my son, they kept getting in trouble. Oh, God.
Your sons?
She never take them to court, so that's how I lost my second job, by trying to get them in court, because she never would take them, because she was out doing drugs, her and her husband selling drugs.
Gloria's husband was selling drugs?
And her.
Do you know if Gloria moved around? And we're going to talk about Ronnie just, up until he's about 18 years of age now when he's living with Gloria. Do you know if they moved around a lot?
Yes, she did.
Do you know if Ronnie then had to change schools frequently because
Oh,
of
yes.
that? Okay. And when he would be with Gloria Hamilton, do you know the environment, the neighborhoods that she would frequently move her and the boys to?
Bad. Because back during that time, it was drugs everywhere. So they didn't have no other choice but to be around there. Because it was all drugs, drugs, drugs. Everywhere you look, it was drugs.
do you know, and only if you know, whether Gloria's neighborhood was violent in any way?
Oh, yes. They was always shooting. Or somebody was fighting. They always, every day, somebody would, even though they would shoot every day. I ain't gonna say people got shot, but they always shot. Always shooting.
Now, that wasn't going on for Mr. Walker's first 10 years where you lived with him.
Oh, no.
Right, okay. All right, now tell the jury, after you lost custody, you gave your children, your boys, and is Nikisha with the boys as well? Or where's?
Yeah, I just let her win them because I still had my own apartment. But I know I had to work, and they had nobody to take care of her. But they didn't bother me about my girls. It was only my boys.
So where was Nikisha then?
She went with Gloria. I took her there.
Okay.
You know.
She's with Gloria as well.
Yes.
All right. So when you lost custody, gave up custody of your children to Gloria, Ms. Hamilton, tell the jury at that point, did you turn to drugs?
Yes.
And tell the jury, Ms. Hamilton, do you suffer from mental illness?
Yes.
All right. Were there times when Ronny Walker was with Miss Mace Gloria that she would prohibit you from seeing him?
Sometime.
What kind of stuff would she do?
Because I tell her sometimes you never watch out for them. You know, you just always let them go. She told me I don't have to come. I don't have any say-so over them. So
did you think that she was, like, adequately supervising them, for example?
Not all the time. No. She didn't supervise them because sometimes when I go, they gone, you know, and little kids, you know.
Little kids, okay. All right. Now, did Tangi, or your daughter Tanya, did she ever reunite with the family?
Yes.
Okay. And when did your daughter Tangi Johnson, and she'll explain about her name, do you know approximately when she reunited with the family?
I think it was August 31st or October 31st of 2 years. It's been 2 years.
Okay. So 2 years?
Mm-hmm.
Gotcha. All right. And Paulette, does she always remain with her father?
Yes, until she remained with him there for a while until I got, you know, I could have got her, but I wasn't in the stage at that time, the right to raise no kids because what I was going through, and I was still young, so I let her stay with her father. I think she was like, Dad got like 10 or younger because he got sick.
Her dad?
Mm-hmm.
All right. And is Paulette, does she have a relationship now with the family, or still have a relationship?
Oh, yes. Always had a relationship.
All right. Okay. Before Ronny turns an adult then, is there ever any time you do get him back and he's living with you?
No, she would never give him back to me.
All right. While Ronny Walker is living with Gloria, your sister, do you know, and only if you know, whether he had any contact ever with his father?
No, never.
All right, let me talk to you about a little bit more recent times. Do you have any grandchildren from your son, Ronny Walker?
Yes, I have 3.
3. Had 3. Tell the jury a little bit about your grandchildren's name, Ronny Walker's children.
Ronny Walker, Ron J. Walker, and Parrish. I don't know her last. I don't know if she had the mother last name. I don't know.
Do you see Paris?
Well, I seen her at her brother's funeral. She went to his funeral. That's the last time I seen her. But she's in the army.
Oh, okay. Very good. Could you spell Ron J's for us for the court reporter, if you can?
It's what now?
Ron J's name.
I think it's AJY. I don't know.
It's okay.
but his mother, no.
Okay. All right, and do you know where Ronny Walker's son is now?
He's incarcerated right now.
Okay. Tell the jury what happened to Ronnie's son, Ronny Walker.
Well, he stayed with his daddy. His daddy got him and kept him and, I call him YK. They kept him for a while because the way his mother was bringing him up, he didn't know anything. I don't know if they were treating him like he was a dog because she had to train him to not eat off the floor. He wanted his food on the floor. So she trained him how to eat, how to take a bath. He didn't know anything.
Tell the jury what happened to Ronell in the last couple of years, please.
Well, I raised after YK still had me. He came and lived with me up until he was like 18. Then he went back and lived with her. He would never go back to his mom because where they treated him. So.
And was Ronell murdered?
Yes, he was murdered.
And do you know if it was gunshot wounds?
A gunshot wound.
Okay. All right. Do you know if that affected Ronnie?
Yes.
Okay. Were there times when Mr. Walker would visit Ronell's gravesite?
Every day.
Did you ever go?
Yes, I just didn't like the environment that was there. So I went out there when it was, I think it was coming up for the day he got killed on, or the day he got killed on.
Okay.
So they always goes out there on the 12th. Yeah, they'll go on his birthday, the 13th,
His birthday or the anniversary of his death?
Yes. Mm-hmm.
About that same time, approximately 2021, did your mom pass away?
Yes.
What was her name?
Thelma Hamilton.
Thelma Hamilton. And was that then Ronnie's grandmother?
Yes.
Okay, Mr. Walker's. Was Mr. Walker close with your mom, his grandmother?
Yes.
Do you know, and only if you know, whether her death around that same time affected Ronnie in 2021?
Yes.
And today, is Ronnie still close to his siblings, the ones he was with and the ones he reunited with?
Yes.
All right, I want to show you some photographs. This will be the time then, if you could read the stipulation concerning Defense Exhibit A, 1 through 6, and then I will approach the witness.
All right, ladies and gentlemen, there's a stipulation regarding the defense composite A 1 through 6. It's hereby stipulated by and between the defendant Ronny Walker and the state of Florida that the photographs introduced in the defendant's composite Exhibit A 1 through 6 were located by Detective Jacob Wieland in Ronny Walker's vehicle.
Thank you, Judge. May I approach the witness?
Yes, you may.
Okay, I'm handing you what has been marked for identification as Defense Exhibit A 1 through 6. I would like you to go ahead and just look at these photographs and see if you recognize the people in them, and then if you do, we will talk about them.
No, you're not gonna publish it.
You expected that I wasn't going to be able to do it?
No, I know you could. Just.
Yes.
Do you recognize the mainly children in those photos?
Yes.
Okay. Your Honor, at this time, the defense would move Defense Exhibit A 1 through 6 into evidence and ask to publish.
Any objection?
No objection.
They'll be admitted as defense A 1 through 6, and you may publish.
Thank you, Judge. All right, A1, Defense Exhibit A1. We're gonna look at these briefly. Who is this, Miss Hamilton?
That's his daughter, Parrish.
That's Paris. And Defense Exhibit A, that's out of order. Let's do Defense Exhibit A2. Tell the jury who was in this photograph.
That's Ron J.
That's Ron J. Okay. Defense Exhibit A3. Who is in this photograph, Miss Hamilton?
It's Ron J and his cousins.
Okay. Ron J is
The
over
one-
here?
No, the one had the white on.
The white, okay. Is it Halloween in this photo?
Yes.
As far as you know, okay. Okay. Defense Exhibit A4, Miss Hamilton, who was in this photograph?
Ron J and his mother.
Okay, and what's his mom's name?
I call her Waikiki. I can't think her name.
You call her what?
I call her Waikiki.
Waikiki, okay. All right, Defense Exhibit A5, who is in this photograph, Miss Hamilton?
Ron J.
This is Ron J. All right. And, oop, I went out of focus. All right, and finally, Defense Exhibit A6, tell the jury who this is.
That's Ron Neal,
Okay. So this is Ronell, the
deceased.
deceased. Okay. All right, may approach the witness. Okay. I'm handing you what has been marked for identification as Defense Exhibit B. I'm going to hand you these. Tell us if you recognize that, and if so, we'll talk about them more.
Yes.
Are you in those photographs?
Yes.
Or partially, right? All right. Your Honor, at this time, the defense would move Defense Exhibit B into evidence and ask to publish.
Objections?
No objection.
To be granted, no public.
Thank you, Judge. Okay, Defense Exhibit B, we're gonna label this 1. There we go. All right. Tell us, Ms. Hamilton, what this picture depicts, please.
Well, we was in the cemetery. It was me, Ronnie, me, and my granddaughter. Well, I don't know who this lady is. I'm sorry.
That's okay. All right, let's point out, just for the jury, this gentleman right here, who is that?
That's Ronny Walker.
Okay, so that's your son, Ronnie,
Yes.
Mr. Walker. And is this you over here? A little
Yes.
bit out of the picture in the blue.
Yes.
All right. And you indicated that woman, though, and I'm pointing to the woman with the gray shirt, the short hair, standing next to Mr. Walker. You don't know who that person is?
No, it was just Ken, I guess. I don't know who they was.
Okay. Okay, Defense Exhibit B2. What does this picture depict?
This is my granddaughter, Paula. That is her son, and Ronny Walker.
Okay.
That's all.
The woman in the white with the shorts, is that Paulette?
Her name is Paula.
Paula.
Yeah, that's my granddaughter.
Okay. Oh, it's your granddaughter. Okay.
Yes.
All right. All right. And this gentleman in the middle here, is that Ronny Walker?
Yes.
And finally, Defense B3, what does this picture depict?
It's me on the end,
Okay.
and Ronnie, and I don't know who the
That
lady
same
is.
woman you don't know.
I'm not
Okay.
going
All right.
to say who it was.
What's happening in that picture? Can you tell? It looks like, are they releasing balloons?
Yeah, they just say we say the prayer, and we release the balloons,
Okay.
and they were just watching them go up.
Okay. And you said the gravesite would be visited times such as the death of Ronell when he was murdered, his birthday, things like that.
Yes, well, they go, his mother and them go out there all the time, you know. I ride by there, but I don't go down there because I don't like the people that hang around. Because at that time when we had his funeral, it was somebody got killed on his grave. Because then they had the different gangs and, you know, stuff like that, saying that this person tore up this grave, and my son was about a guy that had got killed. And
Ronell?
yes,
Yeah.
and they didn't want Ronell grave by him, but it's just a lot of motion going on between the young guys.
So it's tough for you. That's
Yeah,
why you
so-
don't wanna go. Okay,
I choose not to go. So.
understood. All right, and as Ronny Walker was growing up, did you and him talk about the Bible?
Oh, sure, all the time.
All right, and finally, and may I approach the witness one final time, Judge?
Granted.
Okay, I'm handing you what is marked as Defense Exhibit C for identification. Do you recognize the people in that photograph?
Yes,
Your Honor, at this time, the defense would move Defense Exhibit C into evidence and ask to publish.
Any objections?
No objection.
Will be admitted and you may publish.
Thank you, Judge. All right, tell us who the gentlemen are in this photograph, Defense Exhibit C.
it's Ronnie,
Okay.
my nephew David, and my nephew James.
Okay, so Ronny Walker is on the right,
Yes,
and is this Davis George?
yes.
All right, and who is the gentleman on the left?
That's his oldest brother, James.
Okay, that is Davis George's son,
No, that's his brother.
his brother. Got it. All right. And let me just ask you then, Miss Hamilton, and I'm gonna wrap up, and then Mr. Terry or Miss Fawcett will have a chance to speak to you, but do you love your son?
Yes,
Do you support Ronny Walker?
yes.
Yep. May I have a moment?
Yes, ma'am.
Let me take you back real quick to before Ronny went to live with Gloria. Would Ronny stay in his room a lot of times by himself?
Yes.
Okay, do you know why? Only if you know.
I get cause of his sickness, you know. He liked the dark,
Because of his
Like he's-
sickness, he liked the dark. Okay, all right.
like he do now. You know, he loved to stay in the room in the dark.
All right. Thank you, Miss Hamilton. No further questions.
Cross.
Yes, Your Honor, thank you.
Good morning, ma'am.
Good morning.
You are Ronny Walker's mother, correct?
Yes,
And you've always done all that you can to love and support him, is that correct?
yes.
You indicated that you would talk to him about the Bible.
Oh, yes, plenty. Well, he talks to me,
Okay.
you know.
So you tried to instill in him good qualities.
Yes,
Did you counsel him on right and wrong?
yes,
And even though you said you were young, maybe 21, 22, when you had him, did you work?
yes,
Did you work at hotels,
yes,
laundry services,
yes,
cleaning services?
yes,
Okay. And even after Ronny Walker's father left, you continued to try to instill in him good values, correct?
yes.
At any point in time, do you remember at all telling him that it's okay to hurt anyone?
I would never say,
Did you make it a point to instill in him that it's important to treat people with kindness and respect?
I always taught my kids that.
You thought that to all 6?
Yes.
Okay. And when it came time, when Ronny Walker, when you were pregnant with him, you went to the hospital, yes?
Yes.
For your treatments?
Yes.
You took whatever prenatal vitamins you were given, is that correct?
Yes.
You tried to take good care of yourself while you were pregnant with him?
Yes.
As did you with all your other children, correct?
Yes.
In fact, after he was born, you said that he had pneumonia.
Yes.
You saw to it that he got help in the hospital.
Yes.
You visited him while he was in the hospital.
Yes.
You took care of him, is
Yes.
that correct?
Yes.
And ultimately, when you determined that he had seizures, you took him for treatment constantly, correct?
Yes. When he had appointment.
You saw to it that he got to his appointments,
Yes.
even though you had not that much money, is that correct?
Correct.
You still strive to make sure that he was well cared for.
Yes.
You've always loved him,
Yes.
always supported him.
Yes.
Even now you are here in support of him, correct?
Correct.
And you supported your other children as well.
Yes.
And when Ronny was born and you lived in a particular neighborhood, for food you worked and you got food stamps, correct?
Yes.
So he never actually went hungry.
No.
You saw to it that he was well fed.
Yes.
You were never abusive.
No.
You never once hit him or did anything to harm him. Is that correct?
Correct.
And in fact, when you needed to discipline him, you would send him to his room rather than beat him or anything, correct?
Correct.
You made sure that he always had a roof over his head.
Yes.
And from the age of birth till 10, he lived with you.
Yes.
And even after his father left, you continued to support him.
Yes.
You continued to love him.
Yes.
You saw to it that he went to school.
Yes.
You did your best to make sure that when they determined that he was a stammerer, and I think you said he stuttered or he stammered, is that correct?
Yes.
You saw to it that he got help for it at
Yes.
school.
Yes.
When he needed help or when the teachers needed to speak to you about Ronny Walker, did you see to it that you went to the school?
Yes.
Were you intimately involved in in the well-being of your son?
Yes.
And when in fact you couldn't take your son, Ronny Walker, to an appointment and you were about to lose him, you sought family to help out, correct? You sought your sister to help.
Yes.
You didn't want him to just go to anyone, right? So you asked your sister to step in.
Yes.
And your sister did in fact step in.
Yes.
And so Ronny remained with family.
Yes.
And you have a family, you have siblings, correct?
Yes.
And was it that you said that you had 7 siblings?
Yes.
Okay. And 5 are left.
Yes.
At the time Ronny was born, though, you had 7 siblings, correct?
Yes.
And were all of them involved in your life?
Well, we go and see each other, you know.
So you had family around. You come from a big family, correct?
Yes.
And would you say that your siblings showed love and support for Ronny?
Yes.
Did you have brothers?
Yes.
How many?
I had 3 brothers.
3 brothers? Were they older or younger?
1 older and 2 younger.
Did they show love to Ronny Walker?
Yes.
Were they role models to him in any way?
Well, my second oldest brother was incarcerated.
Okay.
My other brother, baby brother, he was in his life.
He was in his life?
Yeah.
Okay. If Ronny needed counsel from a man, you know, as he's growing up to be a man, were your brothers people who were willing to step in to help?
Well, yeah, they would. You know.
How about cousins? Did Ronny Walker have cousins?
Oh, yeah.
Did he have cousins that loved him?
Oh, yes.
Okay. And did you, as a family, do things together? You, your siblings, cousins, did you have big family events?
Oh, yeah, we always have events.
And Ronny Walker was a part of that, correct?
Yes.
And while you do have people in your family that were incarcerated, there were also people who were hardworking and productive, correct?
Yes.
And was Ronny Walker exposed to these individuals in your family that were hardworking and productive?
Yes.
In all the time that even after Ronny Walker moved out and lived with your sister, you went to see him almost every day or every other day, correct?
Correct.
You bought him clothes.
Yes.
You made sure he was well fed and well taken care of. Is that correct?
Yes.
And if he needed if he had any medical needs, you saw to it that he got those needs met, correct?
Well, I couldn't go beyond that.
You couldn't go beyond that. Is that what you said?
If my sister asked me
Yeah,
to do it, I do it.
you would do it.
Yes.
So, and if you saw for yourself that Ronny Walker had a need, would you seek to meet that need?
Oh, yes.
Did you get a second job in order to meet the needs of Ronny Walker?
Yes.
When Ronny Walker was living with you, you didn't drink alcohol, correct?
No,
You never got drunk in front of him or acted unseemly, correct?
no, I never drank. No, they was younger.
Okay. Were you doing drugs in front of Ronny Walker from the ages of birth to 10?
No.
Was Ronny Walker a crack baby? Were you smoking crack? Were you using crack or cocaine or anything when you were pregnant?
No. Oh,
So when you were pregnant, you didn't do drugs?
no.
Okay. Now you said that you had that you suffer from some mental health problems. When Ronny was living with you, were you ever hospitalized for any kind of mental health breakdown?
No.
Okay. So when did you get diagnosed with some kind of mental health condition?
When I got on the drugs.
Which is when? Is it after Ronny Walker left your home?
Yes.
Okay, so after Ronny was at least 10 years old and no longer in your custody, you got involved in drugs.
Yes.
And then you got diagnosed with a mental health condition.
Yes.
But that was not while you were living with Ronny Walker.
Right.
Did you do anything or act out in any way due to your mental illness that have impacted Ronny Walker?
No.
In any fits of mental health, did you ever abuse Ronny Walker physically, mentally, emotionally?
No.
Now, you indicated that when Ronny Walker lived with you, you lived in the back, I think you said in the back area in the neighborhood. Do you remember saying something like that?
Yes.
So this is a quieter part of the neighborhood, correct?
Yes.
And you said that there were older individuals there.
Yes.
And Mr. Walker was born in the 70s, right?
Yes.
And in that time frame, was it sort of like communities helped bring up children?
Well, yes, because they see them do something wrong, they'll say something to them, or they'll come and let you know if they did something.
So the older people in the neighborhood also would help you in some ways with Ronny Walker. If they noticed something wrong, they would tell you,
Oh,
correct?
yes. Mm-hmm.
You all looked out for each other in that neighborhood.
Yes.
Okay. And when DCF got involved and you lost custody of Ronny Walker, it wasn't because you were abusive towards Ronny Walker, correct?
Yes.
It wasn't that, right?
No.
It was simply you missed taking him to some appointments,
Yeah.
correct?
Yes.
And you didn't have a vehicle, so you didn't know how to accomplish that.
Yes.
Okay. Ronny Walker also has siblings,
Yes.
and if you know, do his siblings love him?
Yes.
Do his children love him?
Yes.
Do his cousins love him?
Yes.
Do they show support for him?
Yes.
Have they always shown support for him?
Yes.
And prior to this incident, was Ronny Walker living with you and Erica Sweet?
Judge, may we approach?
Yes.
So Mr. Walker always had a home in your home, correct?
Yes.
And in 2022, he lived with you and Erica Sweet, correct? Okay. And all of his life, if he needed a home, your home has always been open to him, correct?
Yes.
We have looked at some pictures of your family and Ronny Walker. Mr. Walker's children are now, what, 18 and 19 years old, correct?
Yes.
Okay, so these pictures are from when they were younger.
Yes.
All right. For when I speak, this picture, this is his daughter,
Yes.
and she's now, what, 19 years old?
Yes.
Okay. So his children are adults.
Yes.
And his son that was murdered, that happened in 2021, correct?
Yes.
So it would have been prior to the murder in this case, prior to this incident. It would have happened before May the 6th of 2022. Okay. At any time in Ronny Walker's life, have you ever abandoned him?
No.
And you said that you sometimes talk to Ronny Walker's biological father.
Well, it's been a minute.
I'm sorry.
It's been a while since I talked to him.
Okay. But to your knowledge, he's never been in Ronny Walker's life,
Oh, yeah.
which means he's never been abusive emotionally, physically, or in any way mentally towards Ronny Walker.
Practically never met him.
Okay. All right. Your Honor, may I have a moment?
Yes, ma'am.
I have no further questions.
Ms. Hamilton, will you tell the jury what your mental illness diagnosis is, please?
Bipolar schizophrenia.
And are you getting treatment for that?
Well, now, I go sometime and I feel bad.
When Ronny was about 10 and he starts living with Gloria, did he start using marijuana? Can't say? That's okay. All right, and we were talking about you visiting Ronny Walker when he was living with Gloria. Were there conflicts between you and Gloria in terms of how Ronnie's being raised, where he's living?
Well, that's how he was raised, not, you know, we live back in living too, but more how he was getting raised.
And you've described that as living in bad neighborhoods,
Yes,
changing schools a lot, okay?
yes,
The drugs and the violence,
yes.
okay. All right. May I have a moment, Your Honor?
Yes.
Thank you so much, Ms. Hamilton. I don't have any further questions.
Will this witness be excused? Any objection to the witness being excused?
No, she's excused, yes.
You're free. Attorney's approach, go for it. Ladies and gentlemen, we're gonna take a 10-minute break, so you can stretch your legs, get some coffee. I think you might have some creamer by now.
All rise, Your Executive.
Sophie. Where is it? Okay.
You can be seated.
Thank you. Y'all may be seated. Are you doing work?
I thought you was.
Any matters we need to discuss?
No, Your Honor.
Thank you.
let me ask you this. Do you consider the neighborhood you grew up in, South Tampa, a good neighborhood?
Great neighborhood.
Great neighborhood. Did you witness violence in your neighborhood?
You see it here and there, but it wasn't. It wasn't seen as you go to other neighborhoods.
How about drug dealing and drug sales? Is that something that was prevalent in your neighborhood growing up?
It was.
Okay. How often?
Well,
Like, how often would you see it? Tell the jurors.
we played more sports, so we was on the fields, basketball, baseball, boys and girls club. So we literally, our day was playing sports or in school, and that's pretty much was our everyday thing. My basketball team, my friends I grew up with, we went around the city and beat everybody in basketball. So we was athletes.
And you said happy.
Yes.
All right. Tell the jurors, please, describe the differences between the neighborhood you grew up in and the neighborhood Mr. Walker grew up in when he was living with Gloria. Please tell the jury.
Bit difference. The best way I could explain it, College Hill was more dark. You know, when you go over there, it's a different atmosphere. You come to South Tampa, it's just bright, sunny, happy. When we did go over there, my mom let us stay a day, maybe two. All my cousins did want to come stay with us. My mom couldn't allow it too much. Too many of us stayed in one house.
Too many about now. Did you ever live at any point with Ronny Walker when you were young and he was young?
I went to visit,
You went to visit.
but my mom had, most of them, they come over there, try to come visit a couple of days, then they got to go.
Did your mother want you and your siblings to be in the area and stay at the area where Gloria lived?
Nah, no.
Do you consider, I don't know if you can answer it, do you consider that the neighborhood you grew up in and the neighborhood Mr. Walker grew up in under Gloria to be two different worlds?
Two different worlds.
Now, growing up, would Mr. Walker like to be at your home?
Yes, ma'am.
And what kind of things would you do with Mr. Walker?
We like to walk to the store and buy pizzas. I think Hungry Howard's was selling them P-zones, the little subs. So we went to the pool, Robertson High School pool, baseball. Out there used to be the woods. We'd go out there and catch fishes. So we was always just so occupied, so much to do out there.
And Mr. Walker, did he enjoy all of that you just mentioned?
Loved it.
Okay. So did he want to be at your home in your neighborhood more than his neighborhood with Gloria?
Yep. He even wanted to go to school out there. It
He
just, you couldn't. My mom had 8 kids. It's too many people in one house.
So did he want to actually live with you at some point so he could go to school in your neighborhood?
Yes, ma'am.
All right. Despite all of this, your family, your aunts, your cousin, Mr. Walker, his siblings, do you consider you all a close-knit family?
Yes.
Okay. And Mr. George, tell the jury, are all your children successful in life?
Yes. Oldest daughter doing real estate. She's 24. My 18-year-older just graduated, going to University of Maryland. My 16-year-older going to school. She want to be a doctor. And I got 11 and a 6-year-older, all girls.
Okay. All right. And today, do you still have a relationship with your cousin, Ronny Walker?
I do.
And do you love your cousin, Ronny Walker?
He's my favorite cousin.
Your favorite cousin. Was he your favorite cousin growing up as well?
Yes.
Okay. You guys were close.
Very close.
All right. And Mr. George, tell the jury, do you support Mr. Walker today, despite everything?
I do.
I want to just go ahead and show you what's Defense Exhibit C admitted into evidence. Do you recognize the people in this photograph?
I do.
All right. Are you in this photograph?
Yep, I'm in the middle.
You're in the middle. All right. And is this Mr. Walker with the white shirt?
Yes, ma'am.
All right. And who is the person on your right side?
My oldest brother,
And what's his name?
James Powell.
James, all right. Do you remember at all what you guys were doing at the time?
My mom had just got married. This is the reception, and we had a blast. Everybody dancing and everything. I'm just smiling, just looking at the picture.
Okay. Okay, Mr. George, I don't have any other questions for you, but the state will. Thank you.
Thank you.
Yes, sir.
Good morning, Mr. George.
Good morning. How you doing, sir?
We spoke the other day, correct? You were
Yes.
speaking to me? Yes.
Yes.
Now, you indicated that Ronny Walker was your favorite cousin, right?
Yes.
I believe you told me that the other day, too, right?
Mhm.
You all played together?
Yes, sir.
Got along very well, right?
Great.
Grew up together, kind of.
Mhm.
You all close as cousins?
Mhm.
Kind of told each other everything that's going on in your lives?
Yeah.
All right. So you all were good friends, too. Besides just being cousins and familially related, you all were good friends?
Yes.
All right, and did you talk to him about, his life and things that were going on in his life?
We talked about a couple things. Not too big though.
Okay. You guys never fought, right?
Never.
All right, you actually told me, I think, that you all prayed together sometimes, right? So would you say you tried to be a good influence on Ronny Walker as far as like how to live a life?
Yeah.
All right, you all played basketball together?
Mhm.
I remember you telling me that.
Yep.
And if he had ever needed you for any reason, would you have been there for him?
Yes, sir.
As younger and even as he was growing up, would you always have been there if he called you and said, "Hey, I'm in a problem," or I need help"? Would you have come to him and helped him?
Yes, sir.
All right. If he needed advice, would you have given him advice?
Yes, sir.
And did Ronny Walker, did he play any sports?
Not with the Boys and Girls Club, nothing like that I know of. But we came out in our neighborhood. We played Thorpe, Tyco, baseball, everything. So when we came to my neighborhood, he did.
Okay, so did you ever see any seizures from him?
Never.
Okay. And he was able to play all the sports with you and you all had a good time?
Mhm.
Can I have one moment, Your Honor?
Listen,
Nothing further.
redirect.
No redirect?
Ms. Witness, be excused.
Yes, sir.
All right. Thank you.
Thank you, sir. Appointing next witness.
Yes, sir. Your Honor, the defense at this time will call Tangi Johnson.
Do you solemnly swear or affirm that the testimony you will give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, whenever you're ready, if you could let the jury know your name, please.
Tangi Johnson,
All right. Ms. Johnson, what is your date of birth?
April 4th, 1979.
1979. Okay. So you're close in age to Davis, George, and Ronny Walker.
I'm 46.
Okay. So you're 46 right now.
Ronnie's 47.
Ronnie's 47.
Yes.
All right. Are you employed, ma'am?
I work for Tetra Tech. It's a debris removal. I do all kind of disasters.
All right. I want to talk a little bit about some family members. First of all, who are your parents?
Well, my father's name is Earl Williamson, and my mother's name is Emma Hamilton.
Okay. Now, I know there's a lot of history behind you. So
Yes.
let's, who, are they your biological parents?
Yes.
Okay. So Emma Hamilton is your biological mother?
Yes.
All right. And your biological father's name?
Earl Williamson.
Earl Williamson. Okay. Are you presently married?
Yes.
Do you have any children?
Yes.
Okay. How many children do you have?
3.
3? Okay. And do you have any grandchildren?
1. A granddaughter.
Okay. All right. Do you know Ronny Walker?
I do.
What is your relationship to Ronny Walker? What is your connection to him?
He's my brother.
Your brother. Your biological brother.
Yes, ma'am.
All right. All right. Let's talk a little bit about what happened with you. Did you grow up with Ronny Walker up to the age of 10?
No.
All right. Did there come a time when you were taken from your family?
Yes.
How old were you at the time you were taken from Emma and your other siblings?
3,
How old was Ronny Walker?
4.
Tell the jury a little bit about how you were taken from the family.
It was on my birthday. I have 2 birthdays, 2 names. But on my birthday, that was April the 2nd, my father took me and said he was going to bring me back, but he never did. And I grew up in foster care, and so I did ancestry DNA in 2021. And it came back that I had family here in Tampa, which was my mom, and I was able to find my dad's side of the family in Riviera, Florida. So on October the 31st, I came back and reunited with my mom of 22.
Okay, so October 31st?
Mm-hmm.
Okay. Halloween of 2022?
Yes.
Okay. Okay. All right, so when you say that your father took you, I mean, you're only, what, how old at the time you said?
3.
3, okay. Did you want to leave, if you remember, did you want to go with your father at that time?
I don't know.
Okay, of course, all right. Okay, so, and was it your biological father who took you?
I'm assuming so, yes.
Okay. And just let the jury know, when you say you have 2 different birthdays and 2 different names, just kind of explain why you're saying that.
My mom gave birth to me on April 2nd, 1979. She named me Tanya LaShawn Hamilton. But when my dad took me, he changed my name and he changed my birthday to Tangi Williams. And my adopted parent that raised me, they just gave me a birthday, which was April 4th, from another sibling that I had from her. And they declared my birthday to be April 4th, 1979.
And at some point, did you, as you indicated, go on Ancestry.com to try to find your mom's family?
Yes.
Okay. What are the name of your adopted parents?
Well, I was never adopted, but I was raised by a lady named Beverly Fountain. She's from Eustis, Florida. So that's where I spent most of my childhood, growing up in Eustis, Florida.
Okay. All right, so growing up, you and Ronny are 3 and 4 respectively. Did you ever see Ronny Walker, your biological brother, again growing up?
Yes,
Okay. When did you see him?
2022.
Okay. So just recently?
Yes.
And is that when you reconnected?
Yes.
Gotcha. So, when your little children and the siblings, your siblings are living at Emma Hamilton's home with your biological mother, do you ever get to see your brother Ronny Walker?
As a child, yes.
As a child growing up to 10?
No.
No. Right. Going further up to, age of 18, do you ever get to have a relationship with your brother Ronny Walker?
No.
Okay. Was it not then until the Ancestry.com and just very recently?
Yes, ma'am.
Okay. All right. Tell the jury about, so you indicated it was 2022?
Yes, ma'am.
All right. And when you reunited with Ronny Walker, he was incarcerated on this case, correct?
Yes, ma'am.
Okay. Did you visit him?
I did.
Okay. That was your way of making the reconnection?
Yes, ma'am.
Okay. All right. Tell the jury the story about your yellow dress and bow.
Well, that's what he vaguely remembered the first time we talked on the phone. He was like, I can still remember you. I remember what you had on. I'm like, well, you can remember what I had on. It's like 40 years later. He was like, yeah, you had this yellow dress on with this big bow, and you had your hair all was so pretty. And like, I remember that day your daddy took you. You had that yellow dress on. And that's what he stands on, this yellow dress. And so.
Did you have a yellow dress with a bow?
My aunties have told me the same story.
Okay.
So it's definitely truth in it.
All right. And who were your other siblings besides Mr. Walker?
Well, I have a sister named Paulette Hardy. She's my baby sister. And I have a sister named Nakisha Grace. She's the sister under me. And John Boy,
Brothers?
yes, and Antoine and Ronny Walker.
Did you ever get to reconnect with John?
Kinda.
Kinda? Okay. And how about Antoine?
Never.
Never. Okay. Anton, I understand, is incarcerated.
Yes.
Okay, all right. Are you glad that you were able to reunite with your brother, Ronny Walker,
Grateful.
despite everything?
Yes, ma'am.
And when he was in jail awaiting trial on this case, you said that you had some visits and some phone calls with him, is that right?
Yes.
Okay. Did you take your daughter to meet him at the jail?
I did, and my granddaughter.
And your granddaughter?
Yes.
Did you give me your daughter and your granddaughter's name? If not,
My daughter name is Tracy Jackson, and my granddaughter name is Harmony Jackson.
okay. And how did Mr. Walker react meeting his, I guess it would be niece and grandniece?
Great niece, yes.
Okay.
He was very happy. He was more or less wanted them to get their self to, well, wanted my daughter to get herself together. Very encouraging. Make sure you go to school. You know, take care of your baby. You know, everything was just encouragement. You know, he was happy. He didn't have a lot of words to say. He was just looking, and they look alike. So
Oh, yeah, who looks alike?
my daughter and Ronnie looks alike a lot.
Did you ever go to the grave site for your nephew Ronell?
I have never been.
Didn't get to go to the grave site. Okay, all right. So despite what Mr. Walker did, do you still support him?
I do.
And do you still love him?
I do.
May I have a moment, Your Honor?
Yes.
Thank you so much. I don't have any further questions. Mr. Terry will.
Cross-examination.
Yes, sir.
Hello, Ms. Johnson, how are you?
Hi, how you doing?
We spoke the other day, I believe, right, on the
did.
phone? And so, I think I missed this. Where are you living now?
I live in Port Charlotte, Florida.
Port Charlotte. Okay, so you're not too far away.
No, like an hour and a half.
Is that where you grew up, or where did you said Eustis, right?
I grew up in Eustis, Florida.
Okay, Eustis. Okay. Now, going back to when you were 3 years old, do you remember those times at all?
No, I don't.
Okay. So do you have any bad memories of those times growing up, those first 3 years when you were living with your mom?
I do not.
All right. Probably not any good memories either. You probably just don't remember. Is that right?
No, sir, I do not.
Okay. After you were taken away basically at 3 years old and then put in foster care and have been moving around basically, you have not had any connection with Ronny Walker, correct?
Not until 22.
Not until October of 2022.
Correct.
So his growing up years, his 20s and stuff, you had no idea what he was doing, where he was, what was going on, or anything about it,
No,
correct?
sir.
All right. And it wasn't until after this incident where he was already in jail that you first got to know Ronny Walker again, correct?
Correct.
All right. And you visit him, you said 2 times, right, in the jail?
Yes,
All right. And you've spoken to him by phone a couple of times as well from the jail?
correct.
All right. If I may have one moment?
Yes.
Nothing else.
May we direct?
No redirect.
May the witness be excused?
Yes, yes, Your Honor.
Thank you.
State?
Yes.
Free to go, ma'am.
Thank you.
Thank you. State, our defense may call our next witness.
Yes. The defense at this time will call Renisha Brown. Please let the jury know your name, ma'am.
Renisha Brown,
And what's your date of birth?
120598,
How old are you presently?
26.
And ma'am, are you presently employed?
Yes,
How are you employed?
I work at Department of Juvenile Justice.
What do you do there?
I help rehabilitate young juvenile offenders
How long you been doing that?
for about 2 years.
Okay. All right, tell me how you got your name, Renisha.
I'm named after my Uncle Ronnie.
Okay. And Ronny Walker, so your relationship to him is he is your uncle?
Yes.
Now, so tell the jury, there's a lot of names here, who are your parents?
My mom is Nikisha, his sister.
So Nikisha Grace, is that her last name?
Yes.
All right. And Nikisha Grace is Ronny Walker's sister,
Yes.
and you are Nikisha's daughter.
Correct.
Do you have any children of your own?
Yes.
How many do you got?
I have 2 daughters.
All right. No grandchildren yet?
No, they're young, 10 and 3.
Okay. So, were you named after Ronny Walker?
Yes, Ronnie and Ronisha.
Ronny and Renisha. Okay.
Yep.
Okay. All right. Now, I understand, Ms. Brown, that you prepared a statement that you would like to read to the jury. And, Your Honor, if she could read that at this time, I don't think Mr. Terry has any objection.
That's fine.
Okay.
All right, Ms. Brown, just give me your statement.
Thank you for allowing me the opportunity to speak. I want to begin by acknowledging the seriousness of this situation and the pain that has come from it. I do not take this lightly. I am here today because I knew my uncle in a personal way growing up. He was someone who supported me during difficult times and encouraged me to stay strong. In the family, he was present, and there were times he showed and care and concern for those close to him. I understand the court has found him guilty, and I am not here to question the verdict. I believe in the possibility of growth, and I hope he finds a way to make peace with what happened.
And do you still support Ronny Walker despite what he did?
Yes,
And do you still love him despite what he did?
I do.
Okay. Ms. Brown, I don't have any other questions, but Mr. Terry will.
Cross-examination.
Hello, Ms. Brown, how are you?
I'm good.
Ms. Brown, we met, what, a couple weeks ago probably?
Yeah.
And I took your deposition?
Yep.
Now, I have a question for you, because you just said, what do you say you're doing right now?
Department of Juvenile Justice,
What do you do for them?
rehabilitate young offenders.
All right. When we met, didn't you tell me you were a security guard?
Yeah, that's the same thing,
Oh,
but
you're working there as a security guard?
Right.
or- Okay, I was just confused when you
Yeah.
said that working. I had 2 different jobs in my head. So.
no, the one that I told you at the port was temporary, and this one now is full-time.
Okay, so that was a temporary job you were doing, and now you're working full-time.
Correct.
So have you just started this job, or have you been working?
No, I was full-time. I resigned for a little bit, and now I'm back.
Okay,
But
so
both
when you
jobs
resigned,
is,
You were working at the port.
all of it is security.
Okay, all right. I was just trying to clear that up in my mind. Thank you.
Yep.
Is that it?
Okay.
This one is good to you?
Yes, and I'll read her
I'll
out.
read it. Thank you, ma'am.
Can we have just one moment?
Sure.
I hope I pronounced this correctly. Defense at this time will call Lisa Jonicia. She can pronounce it.
Do you solemnly swear or affirm that the testimony you will give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Pronounce your name for me.
It's Issa Jonasia.
Okay. Can you spell that for our court reporter?
YSSA. Last name is JONESIA.
Okay. And what's your date of birth?
4480.
And how old are you right now, ma'am?
45.
Okay. And are you currently employed?
No.
Okay. All right. I would like to ask you, do you know Ronny Walker?
Yes.
Do you have a child in common with Ronny Walker?
Yes.
And what is his name?
Ronjay Walker.
Okay. Can you spell that for the court reporter, please?
First name is Ronjzae. Last name Walker, Walker.
Where is Ron J's now?
Incarcerated.
How old is he now?
20.
Okay. You could see him still?
Yes.
I want to show you what has been admitted as Defense Exhibit A4. Do you recognize the people in this photograph?
Yes.
Who is in this photograph?
Ronjay Walker and myself.
Okay, all right. Defense Exhibit A5. Who is this?
Ronjay Walker.
Okay. Did you know Ronell before he was murdered?
Yes.
Okay. Did you ever see him when he was young?
Oh, yes.
Yeah? Okay. All right. I may not be this young, but
Yeah, that young.
Defense Exhibit A6, do you recognize that photograph?
Mm-hmm.
All right, and who is that?
Ronell Walker.
Okay. And is that Ronnie's son who was murdered?
Yes.
Do you know, and only if you know, whether Ronny Walker never knowing his father affected him?
I believe it did. It did.
From what you have seen, is Ronny Walker's family close-knit? Can you describe it that way?
Yes.
All right. Have you ever went to Ronell's gravesite?
Yes.
Okay. Did you ever go when Ronny Walker was there?
No.
Tell the jury the death or the murder of his son Ronell, if you can tell us, did it appear to affect Ronny Walker?
Oh, yes.
All right. I just want to ask you, did Ronny appear to you at all to like have any learning disabilities or be slow? If you can answer the question.
I wouldn't say slow,
Okay, sure. You just
but maybe some learning disabilities.
Okay, all right. Did he ever stutter around you?
Yes.
All right. And when Ronny Walker was incarcerated for this case, for the death of Miss Alexander, did you visit him in the jail?
I think I visited him once.
And any phone calls?
Yes.
Okay. And did Ronny Walker, while in jail on this case, ever get to talk to Ron Jace,
Yes.
your son? Okay. Your son in common. All right. And just tell us, does Ronny Walker, did he try to encourage Ron Jace when he would speak to him on the phone?
Yes.
Okay. So ma'am, I don't have any other further questions.
Okay.
Ms. Fawcett is going to. Thank you.
Cross-examination.
Thank you. Good morning, ma'am.
Good morning.
You know the defendant because you used to date him? Is that
Yes.
correct? Okay. And you dated him for about how long?
Maybe like a year and a half, 2 years.
Okay, about a year and a half, 2 years?
Mm-hmm.
And in that time, did he live with you in your home?
Yes.
Okay. Was it in an apartment?
Apartment.
Was the apartment in your name?
Mm-hmm.
Was Ronny Walker working?
Not at the time.
Were you working?
Yes.
Okay. So you were working, you were paying the bills?
Yes.
Okay. And during that time, did you get pregnant?
Yes.
And about how far into the relationship was it that you had a child with Ronny Walker?
I think it was about 7, 8 months into the relationship that I became pregnant.
Okay. And then you had the baby at a hospital?
Mm-hmm.
Was Mr. Walker present for the birth?
No, he was incarcerated.
has Mr. Walker been very much involved in the relationship with your son?
Judge,
Yes.
may we approach?
Yes. You may continue.
Thank you. Now, you mentioned that your son, how old is your son now?
20.
20. And in the time, has Ronny Walker spoken to your son?
Yes.
Okay. About how often has he spoken to your son, to your knowledge?
They speak whenever they can. They speak a lot. I mean, as much as they can,
Okay.
they speak. Yes.
In the 20 years of your son's life, has Ronny Walker played an active role in your son's life?
Judge, objection.
You can just answer yes or no. if
Yes.
You can. He has?
Mhm.
Okay. How so?
He speaks to my son as much as he can. He talks to him. He try to encourage him, stay out of trouble, you know.
Okay. Did Ronny Walker ever take care of your son financially?
No.
Did your son attend sporting events? Did he play a sport of any kind?
He used to play football.
Did Ronny Walker attend any of the football?
No.
Okay. Did Ronny Walker help your son with any schoolwork or anything like that?
Approach.
Yes.
He's been incarcerated.
At any point when you've been raising your son, have you ever had to take him to the hospital or for doctor visits or anything?
Yes.
Did Ronny Walker attend any of those visits?
No.
While he was attending school, was there ever a time you had to go to the school to speak to the teacher or principal or, just regular events with your son?
Yes.
Did Ronny Walker attend any of those events?
No.
Judge, if I can have a continuing objection to what was discussed.
Same here.
Did Ronny Walker help financially with your son?
Ask and answer.
Sustain.
In the time that you have raised your son, have you had a lot of social moments with you, your son, and Ronny Walker? Picnics, the beach?
Yes.
Okay, about how many of those events would you say you've had with yourself, Ronny Walker, and your son?
can't count. I can't give you a specific number, but it's been plenty.
It's been what?
It's been plenty of times. I can't give you an exact number,
Okay, so
but I mean, we have done things together.
such as what?
Out to eat, beach, school. We've done things that people do together.
Okay. And about how many times would you say?
Over 10.
Over 10 in the 20 years?
Yes.
Okay. Did you meet Ronny Walker's siblings?
Yes.
Okay, so he does have a large family, is that correct?
Mm-hmm.
And he has a loving family.
Yes.
And you have not been in a romantic relationship with Mr. Walker since after your son's birth, thereabout, correct?
Correct.
But you have been supportive of him.
Right.
You're here in support of him.
Yes.
And when you were in a relationship with him, you supported him, correct?
Yes.
And in all the time that you have known Mr. Walker, have you ever witnessed him have a seizure?
No.
Did you ever rush him to the hospital at any point in time?
No.
To your knowledge, was Ronny Walker able to work?
Objection, speculation, relevance.
I'll sustain this as speculation.
Okay. Your Honor, may I have a moment?
Yes, ma'am.
I have no further questions.
You read it around?
One moment. Just one more question for you.
Mhm.
What is the date of birth of your son?
2005.
2005.
Mm-hmm.
No further questions. Thank you, Judge.
May this witness be excused?
Yes, she may.
Yes, Your Honor.
No objection?
No.
You're free to go, thanks.
May we approach, Judge?
Yes. Anything on the 10-minute recess, and then we'll get back at it. Thank you. Court will be in recess.
All rise, your executive.
Presiding young lady, seated. Any matters we need to discuss?
No, Your Honor.
Thank court will be in recess for 10.
Thank you.
Court will be in recess.
Judge, I just, would have you confirm with Mr. Walker that he's okay with waiving sequestration.
Mr. Walker, could you raise your right hand? You swear affirm that the testimony you gave will be the truth, the whole truth, nothing but the truth? The rules require that when the jury deliberates, in either the guilt and the penalty phase, that once they start deliberating, they shall be sequestered unless the parties agree and both parties agree to waive that. And at the first part, you, after talking to you and the state, you all agreed to waive that first sequestration. Now, again, we have that situation coming back up. Is it your wish to waive sequestration once again?
Yes.
And you did that after speaking with your attorneys?
Yes.
Nobody's forced you or threatened you to make that decision? All right, very good. Thank you, sir. I appreciate that. All right.
And the state's okay with that?
Yes, the state's okay.
All right, very good. We will see you all 4:15.
Thank you.
Yeah, they released something good this morning.
Yeah, I'm watching a live blog of releases.
Anything else you want to say?
No, we just, what have we done so far? Trump thing.
He took away Medicaid.
school records and evidence pretty much
No,
matches.
that's not true.
That's fine, we're comfortable with that, because that's inaccurate.
She wanted you to include convicted.
Oh, under, maybe a mistake.
They got the records. You want it. They don't have the records. Well, did I do? You can't even see them. It's like, what? I thought it was up to the same place. So now, but so now I'm going to say, we go through passes it. Which isn't true. They can't say, they won't say. So they can't say that. Because it's not, it's not, it's a lie. It's a no, they know who won it. So it's just like, for his own statement.
I'm fine with it.
You can say it to the doctor, it's not wrong. And now they're going to state and make it consistent with the trial record. And deliver.
That's a different objection. The instruction should say this. They're working it out.
Uh-huh.
But the fact that something that's not in the record contradicts something that's in the record.
There's nothing in the record.
Right, there's nothing in the record.
So you could say, there's nothing in the record, so you know that in the record. Or anything, you could pick anything. Just nothing. What's that? There's no way to play at least the sixth grade, and really probably most of the seventh.
That's a different objection.
I don't even know where, you know.
I just don't know if that's true. I don't know what the record says.
It's a true fact. The person
I don't know that that's true. I just haven't seen anything that the doctor that I've ever seen. The report says that the doctor said, I
And-
don't
and
know
the
if it's
defense
for the
raised
doctor.
it.
The doctor just said, I don't know.
No, they agreed with what the doctor said. And they said, well, even though our doctor got that information from the doctor, I'm not calling my doctor. So there's nothing in the record. It doesn't give him criminal history on it.
No,
That's my going with this.
correct.
Okay.
That just means that it's different.
I agree, but they're saying, they said he didn't get past this at the grade and alleging. That's what I'm talking
Different statements, it's entirely possible that he never did it immediately.
about. It's possible you could, you can just do it. You just say that too.
Well, no,
You're gonna email that to my Jay, right?
Emailing it, right?
All right.
You want me to?
Yep.
So, do you want me to?
I'll get it.
She doesn't want to be included.
those. Thank you. What's that? Yeah. Well, they forgot to put the felony on the, internet.
No, I know.
After that change, does everything look right?
It does, Judge. I just, renew any motions filed specifically to my proposed restriction of mercy, which is in the record.
All right. They haven't arrested, they're planning on calling a witness.
No, I know.
I mean, that's premature. Any word on
We'll
the,
be resting. Yeah,
are you gonna rest? All
yeah,
right.
we're not.
Have you had an opportunity to speak to
We've
Mr. Walker about the colloquy, or about the?
Yes.
All right, Mr. Walker, I previously put you under oath. I'm asking now at this point, you understand you had a right in this phase also to testify or not to testify as well? And have you discussed with your attorney which option you'd like to take? And what would you like to do? Okay, very good. Nobody's forced you or threatened you to make that decision? All right, thank you, sir. All right, I guess we're ready for the jury. All set, we're ready.
All rise. Jurors entering.
Jury's back, you may be seated. Welcome back, ladies and gentlemen. Once again, I ask, were there any issues, no conversations with each other about the case? No one approached you? You didn't approach anyone by any means? No media contact? All right, very good, thank you. Members of the jury, you have heard all the evidence and the argument of, what?
Judge. Just have to rest.
You already did the argument? I got to rest first, right?
But not
Okay, I understand that. What says the defense at this point?
The defense at this time rests, Your Honor.
All
Thank you.
right, we're gonna be closing?
Yes.
Go ahead. Whenever you're ready. The, read the instructions well. Please.
Your Honor, may I proceed?
Yes, ma'am.
May it please the court, counsel, members of the jury. On May the 6th of 2022, the defendant, Ronny Walker, made up his mind that that was the day he was going to kill Nilexia Alexander. One of the aggravating factors that we indicated to you that we were going to prove was cold, calculated, and premeditated. And members of the jury, we have done that. Mr. Terry told you during the opening statements that you would be allowed to consider all the evidence that was introduced during the guilt phase. So let's go over the steps that the defendant took to see to it that he killed Nilexia Alexander. He obtained a firearm. He loaded it. He made sure that he would have enough to actually kill her. He got Robert Creed. He says, let's ride. He gets into his vehicle and he says, we are going to find her. He drives around, he looks for her, he pulls around, and you have this video. This is the video in which she ultimately walks towards the car, and we know she enters the vehicle. He has her enter the vehicle, and he gives her a false sense of security, because as you can recall, he stopped and bought her something to drink, which is that drink that you see her on the ground with as she's shot. They drive to this location. He gets to this particular location. You see the vehicle drive down North Highland. He makes a U-turn, and he purposely is either in the middle of the street or very close to that empty lot. He stops. He turns off his light. He asked Nilexia Alexander if she was having sex. And when she said no, he shot her, which means that there would have been no answer that would have been appropriate. He had already decided he was going to shoot her. So that's what he did. He shot her, realized she wasn't dead, had her get out of the vehicle. In her own strength, she must have gotten out of the vehicle because that's the only thing that the evidence supports. That's what Robert Creed said, and that's what the evidence supports. She wasn't dragged. She then obeyed. At first she said no, but now she gets out of the car. And she gets out of the car and doesn't go far. But he shoots her again in the head. And he shoots her again in the head. And he shoots her again in the head. He shoots her 3 times in the head. And why is that important? Because there were actually 6 shots, if you recall. There was the first shot. Then there's about 9 seconds. But don't take my word for it. Listen to it. So Nilexia is in this remote location. And if you go by the mileage and the distance, even if she wanted to walk all the way back to where she was picked up, how long would it have taken her? An hour, 45 minutes? But she gets out of that vehicle. And in that moment, the defendant continues his cold, calculated, premeditated decision to kill her because she's out of the car, but he shoots her again. And this is how we find Nilexia Alexander. And here is the drink that he bought for her. Here's a picture of Nilexia Alexander. Why is this important? Because this eye is swollen and you see soot and stippling. That means, members of the jury, that after he shot her, or at some point in the sequence of events, D3, he shoots her in the back. This would not have been fatal. So this shot in the back is the shot she would have had to have first. Then she gets out of the vehicle, bleeding, into this remote location. But he shoots her again, D7. D9. Right in the cheek. Again, remember the testimony of the medical examiner. This soot and this stippling is very important because it shows that the barrel to face is about 12 inches. That's what we're talking about. This is somebody who would have had to bend right over and pull the trigger. Ronny Walker elected to do that. And let's not forget that there were 6 shots. She was shot 4 times, but she was shot at least 2 more times. So let's talk about all the other evidence of cold, calculated, and premeditated. He even dressed for this process. It's May the 6th of 2022. It's warm. But Ronny Walker is wearing a winter jacket. He makes sure he has someone in the car with him. He makes sure that he has chosen this location. You know he's chosen the location because he drives there, knows about this dead-end street, makes the U-turn, turns off the light, and has that conversation. Members of the jury, make no mistake of this. This was not an argument. This is him asking her a question. Are you having sex? And when she says no, he shoots her. This is not a heat of the passion situation. This is not an argument in which he got mad and then shot her. No, that's not what the evidence supports. He had already believed in his heart, or the evidence shows that somehow she had given him an STD. Now you heard testimony. The medical examiner checked Nilexia Alexander. There was no evidence of that. But he believed it. And so this was the plan. And after he had Nilexia Alexander get out of a vehicle in a remote location at 3 a.m., 3:08 to be exact, in the morning, shot her the first time, shot her the second time, shot her the third time, shot her the fourth time, all 3 in the head, he made sure to then drive off, lights off, and then leave. Goes to the gas station, Thornton's. Casually walks in with his jacket up, does whatever he needs to do, drives home, goes about his day. When asked about this incident, he says, hey, I was in the car with someone else. David White, Day-Day, you remember that? That's what he says. He lies.
Judge, I'm gonna object, that's improper argument.
I'll rule the objection. Ladies and gentlemen, what the attorney says is not evidence. It's simply argument. You're relying on your own memories of what the evidence is.
So go by your memory. When law enforcement, and you have the recording that you can listen to. He was asked, you know that time when you're at the Tampa General Hospital, who is that person? Who is that person? He's like, yeah, I think that was Day-Day. I think, let's see. And that's how we checked his phone records, remember? And we got David White to testify. And in fact, it wasn't Day-Day, it was Robert Creed. And Robert Creed got out of that vehicle at Tampa General Hospital, remember? It wasn't David White. And when asked, who's your girlfriend? He says, Erica Hudson.
Judge, again, I'm gonna object. This has nothing to do with events leading up for something to be cold calculated and premeditated. These are events after.
I'll overrule the objection.
So, all of this evidence is what we use to prove cold, calculated, and premeditated. And that's one of the aggravating factors. We told you, and Judge Fuson has told you, I believe, through the instructions, and if he hasn't, we will read the instructions to you, that the state has to prove at least one aggravating factor beyond and to the exclusion of every reasonable doubt. And one of the aggravating factors in this case is cold, calculated, and premeditated. And the state...
That's not correct. It's not the full name of that.
But
noted that we would prove beyond a reasonable doubt is the prior violent felony. And members of the jury, if all we did was provide you the certified convictions, that would have proven the prior violent felonies. So you will have these certified convictions. And as you can see, manslaughter with a weapon. And burglary of a dwelling with assault and or battery, and robbery with a firearm. Now, you did hear from Raymond Lee. And he told you how this event occurred. He said that on October the 23rd of 2003, he was at home with his little girl and his girlfriend, Elaine Caldwell. Elaine Caldwell was in her bedroom doing her hair. He had just clipped the nails of his little girl, and he's just minding his business in his own home when the defendant shows up with a gun, comes into his home, and into Elaine Caldwell's home, demanding money. Right? And he demanded the money. He got $500. He wanted more. He says, "Is there anyone else in the house?" They then go to Elaine Caldwell's room. And she freaked out. She was upset. She was scared. And in the process, and during this invasion of Raymond Lee's home and Elaine Caldwell's home, Elaine Caldwell gets shot in the head in her home at around 8 p.m. while she was doing her hair in her home. Raymond Lee didn't know the defendant. They didn't know him. And after Elaine Caldwell was already shot, he then continues to ask for money. And they do this whole thing of, "Oh, let's go to the car." And then they get past this situation. During this home invasion, he puts a gun to the child's head. He puts a gun to Raymond Lee's head. He puts a gun.
Hold on.
Arguing facts, not in evidence.
Ladies and gentlemen, it's argument. Rely on your own memories of what the evidence is. We continue.
And he points the gun at Elaine Caldwell. And it is in the process of this burglary of this home that Elaine Caldwell had every right to be in, that Raymond Lee had every right to be in, that they lived in, that it's in the process of this that Elaine Caldwell is shot in the head and dies on scene. So, members of the jury, that was the other aggravating factor that the state had to prove beyond and to the exclusion of every reasonable doubt. And it's the state's position that we have proven these two aggravating factors beyond and to the exclusion of every reasonable doubt. So let us talk about the jury instructions. So you will have these instructions. The aggravating factors alleged by the state are: Ronny Walker was previously convicted of a felony involving the use or threat of violence to another person. The crimes of manslaughter with a weapon, robbery with a firearm, and burglary of a dwelling with assault or battery are felonies involving the use or threat of violence to another person. The other aggravator, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit the murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. Now, here, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, and premeditated nature of the murder. And this is why I brought to your attention the fact that all the defendant did was ask Nilexia Alexander a question. Are you having sex? No. Shots fired. He shoots her and tells her to get out of the vehicle. Now, members of the jury, it's the state's position that we have proven these two aggravating factors beyond and to the exclusion of every reasonable doubt. Now, as we explained, and as you're going to get these instructions, as explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. And then you will have the instructions for reasonable doubt. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life in prison without the possibility of parole. Okay? Now, as we talked to you even during the voir dire, if you do unanimously find the existence of at least one aggravating factor, and that aggravating factor, and that the aggravating factors are sufficient to impose a sentence of death, then the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life in prison without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. And so we have the mitigating circumstances, and these have been listed out and will be listed out for you to consider. So let's discuss them. Ronny Walker suffered from a seizure disorder from birth and was placed on medication at times and had to go to the hospital because of these seizures. Ronny Walker's mother said that he had seizures. So you can give it whatever weight you see fit. But I would also point out that his cousin and the mother of his child never saw him have a seizure as an adult. But you should consider the mitigating circumstances, and you can give it whatever weight you see fit. Now, it goes on to say, because of his seizures, Ronny Walker suffered head injuries as a child. You can consider this mitigator and give it whatever weight you see fit. Ronny Walker was hospitalized with double pneumonia and bronchitis at the age of 6 months. That's something for you to consider and give it whatever weight you see fit. Ronny Walker was sick as a child and received treatment at USF Health. Ronny Walker never knew his biological father, and witnesses have said this affected him. Ronny Walker was initially raised by his mother, a single parent. Yes, he was, members of the jury, but you also heard from his single mother, who always has supported him, who came here supporting him, always does. She always had a home for him to stay at, always took care of him. But yes, the evidence does support that he was raised by a single mother and a big family, people who loved him and supported him, and a community. So you can give that whatever weight you deem appropriate. That his mother suffered mental illness, she did say so, but she indicated that that would have been after Ronny Walker was already out of the home, and that she never had an episode or anything that affected him. But you can give it whatever weight you see fit. That he grew up in the projects and he witnessed drug dealing and violence. That his guardians sold drugs while raising him. That that HRS was involved and took Ronny Walker away. And remember, though, he was placed with another family member and had a lot of family. That on some occasions his aunt did not allow his mother to see him. But if you recall, she indicated that she would see him almost every other day. That she would show up, she made sure he had clothes, she got a second job to make sure she supported him. That Ronny Walker's family was torn apart when he was young, and that is where his sister moved away, and then you heard about the dynamic of his family. That he attended 5 different schools, that the school records in evidence reflect up to the 6th grade. That his school records verify he was found and placed as severely emotionally disturbed at the age of 9. At the age of 11, he was placed as a profoundly mentally handicapped, is how it reads. So you can give all of this whatever weight you see fit. Ronny Walker had 3 children. Ronny Walker's son was murdered at the age, in 2021, and that's something you can consider. But also consider that Nilexia Alexander was shot in the head 3 times.
Objection. May we approach?
Yep, come on up.
So members of the jury, you are going to get the instructions, and you will be required to weigh the aggravating factors against the mitigating circumstances. So you can consider that Ronny Walker's son was murdered in 2021, and you can consider the aggravating factors of cold, calculated, premeditated, and the aggravating factor of the prior violent felony. You can consider and weigh the aggravating factors against the mitigating circumstances. That Ronny Walker was greatly affected by his son's death and would frequently visit his grave. That his grandmother died around the time his son was murdered. That his other son, is currently in prison. That he is supported by his mother, his siblings, his cousin, and additional family members. That Ronny Walker offers support and encouragement to family members. That he was employed at the time of his arrest, and according to his supervisor in the guilt phase of the trial, was a good worker and did many different tasks asked of him. That Ronny Walker was cooperative with officers with Tampa Police Department in this case, and he voluntarily spoke with them for a lengthy period of time. You can consider that, and you can also consider what he said, right? If he was completely honest when he spoke to law enforcement, you can consider that too. Ronny Walker consented to the search of his vehicle prior to the officers obtaining the search warrant. He voluntarily gave his cell phone to the officers. You can consider that, but you should also consider the phone records that would indicate that that phone he handed over to law enforcement was activated after the murder. It would have been, if you look at the boost information on the phone download, it was May the 11th of 2022. Consider also that the phone number he provided prior to the murder, that phone was not activated at the time of the murder. But you can consider all of this in mitigation. That he consented to a buccal swab in the case. That he exhibited appropriate courtroom behavior. That Ronny Walker's prior violent felony convictions were the result of a plea bargain offered by the state of Florida. The offenses occurred on October the 23rd of 2003, and all three convictions were a result of a single incident almost 22 years ago. That Ronny Walker was 25 years old at the time of the prior felony conviction for which he pled guilty to. According to the testimony from Raymond Lee regarding Ronny Walker's prior violent felony of manslaughter, there was a struggle for the gun, and when it went off, Ronny Walker did not intend to shoot and kill Elaine Caldwell. The existence of any other factors in Ronny Walker's character, background, or life or circumstances of the offense that could mitigate against the imposition of the death penalty. That Ronny Walker, if convicted at trial as charged, will never be eligible for parole and will die in Florida State Prison, and that he's worthy of mercy. Members of the jury, it's the state's position that Ronny Walker, as you know, is, as you have determined, guilty of premeditated first-degree murder. But it is also the state's position that the state has proven beyond and to the exclusion of every reasonable doubt two aggravating factors beyond and to the exclusion of every reasonable doubt. One involving an incident with a very violent prior felony. The other being this cold, calculated, premeditated manner in which Nilexia Alexander was murdered. You can consider murder. You can consider mercy, but death is an appropriate sentence too. And the state is asking for a verdict of the death penalty. Thank you.
Schlemmer, whenever you're ready.
May it please the court, counsel. Again, when I spoke to you, I think it was Wednesday morning in opening, I said thank you, and thank you still for your service, and thank you for the work you will do back in that jury room. It is almost time for you to make a very, very difficult decision, and maybe the most difficult of your life. Ronny Walker, pursuant to your verdict, as I said in opening, dies in Florida State Prison. The only decision you have to make is at whose hands? By execution or natural death or other reason while in prison. He never gets out. He is being punished and will be punished for Nilexia Alexander's death. You can be assured that. Never will walk the streets as a free man ever again. Now, I want to address first the two aggravating factors that the state has alleged they have proved unanimously beyond a reasonable doubt. And I'll start off with the prior violent felony. These are things that you can consider, and you heard from the jury instructions that Ms. Fawcett had just read out, mitigating circumstances. They are mitigating circumstances. The prior violent felony is an aggravating factor under the law in the state of Florida, but you can consider this information. This incident occurred in October of 2003. Mr. Walker was 25 years old at the time. This was 22 years ago, and I'm not excusing it. Please remember that. Not excusing the actions of the prior violent felony, nor excusing any actions, as I mentioned in opening, concerning the death of Nilexia Alexander when we present the mitigating circumstances to you. Mr. Walker took responsibility for those actions and he pled guilty. You saw that on the judgment and sentence, and the judge told you that. Ms. Fawcett continued to say the quote, little girl. Well, remember back to the evidence, you never heard it was a quote, little girl. No, that might not make much of a difference to you, and certainly, again, I'm not excusing what happened, but that is just something that I point out to you. Also, if you remember Raymond Lee's testimony, he didn't even know that Elaine Caldwell had been shot when they all went outside. This was a robbery and a burglary that went horribly, horribly wrong back in 2003 for the death of Elaine Caldwell. Robbery and burglary are illegal. I'm not excusing them either. But it was a robbery and a burglary that went terribly, tragically wrong. What is very important is Mr. Lee told you that Mr. Walker never pointed the gun at Elaine Caldwell and pulled the trigger. They had a struggle over the gun, and make no mind, I completely agree with Ms. Fawcett. Mr. Walker had no right to be in that home, no right to ask for where's the money, but he did not intentionally go in there and shoot Elaine Caldwell. Raymond Lee told you that, and he was there. They struggled over the gun, which Mr. Lee had every right to do, and it went off. And Mr. Lee told you he even thought it had went off in the ceiling. You can consider that, and that is one of the mitigating circumstances. A struggle for the gun, unintentional. Now I want to direct your attention to the cold, calculated, and premeditated without pretense of moral or legal justification. And I have to direct you back to some of the facts and evidence during the first portion of this trial for that, and I ask you bear with me. Ms. Fawcett has went through what needs to be proven for cold, calculated, and premeditated without pretense of moral or legal justification. And I'm going to go over the instruction again after I have reviewed the facts. But all these facts I'm about to give you, you saw mainly in the video which shows the car turn onto Floribraska and the testimony of witnesses. So I direct you to the testimony of the witnesses, the neighbors, and that video. And all of those items are in evidence, and you're welcome to look at anything again. And again, nobody is questioning at all your finding that this was premeditated. But this is different. This aggravator is it's a heightened premeditation, much, much different than what you found. And we would submit that aggravator, not premeditation, you have found that, not questioning that, but the heightened nature, cool and calm reflection, that does not fit this case. So that aggravating factor requires more than the state presented. A lot of the argument for the for that aggravator, which a lot of times we call CCP. A lot of argument is theory, speculation, and conjecture. I want to go over some of the evidence in helping you make the decision if that has been proven, that aggravating factor, beyond a reasonable doubt, unanimously. So every one of you must determine that that has been proved unanimously, beyond a reasonable doubt, to be able to consider it. The same applies for the prior violent felony convictions he pled to. Same applies. You all have to be unanimous that it has been proven beyond a reasonable doubt. All right, well, first off, and I want you guys also to rely on your own memory, but this is some recollection. There was no communication that evening at all between Mr. Walker and Nilexia Alexander of any threats, of any, in fact, there was no communication between them. We know it was Mr. Creed. But either way, there's no communication of a threatening nature. There's no communication of a plan to lure her there so he could kill her. There was no evidence of that. Mr. Creed said that Mr. Walker came by and they went out in Mr. Walker's vehicle. And Mr. Creed said that Mr. Walker was looking to find a girl for Mr. Creed. Mr. Creed told you that. Along the way, Mr. Creed testified to the following, quote, Mr. Walker was looking for the girl. That's it. That's it. Looking for the girl. Not looking for a girl, the girl, not even sure who that is, but looking for the girl, not to kill her, not to hurt her, not to maim her, not to shoot her, just looking for the girl. That's the evidence you heard. They end up in an apartment complex. You saw the car drive into the complex. It was extremely well lit where Nilexia Alexander was picked up. When Miss Alexander gets in Ronny Walker's car, again, you saw the parking lot very well lit. All of these factors go to that heightened premeditation that does not exist in this case. Premeditation, yes. Heightened, no. And we'll go through the full instruction. There is no evidence whatsoever that he lured her, or he intended anything bad. You didn't hear any evidence such as that. The drive along the way was 1.3 miles from where Nilexia Alexander was picked up to Highland and Floribraska. The car, it was about 2:59 and 21 seconds, and I'm using the time from the video. It was off about 7 minutes, but I'm using the time and it explains the sequence and the time in between. So the vehicle drives down Highland, has its lights on, turns left onto Floribraska with its lights on, and the car goes down. I think Ms. Fawcett even said the car goes down Floribraska, goes out of view a little bit, obviously must make a U-turn, and comes back. Mr. Walker, if he had a heightened premeditation with substantial reflection for cold and calculated, could have stayed at that dead end. Why not stay at that dead end? But he did not. The vehicle, still with its lights on, came in front of the area where there was no home there. It was a vacant lot. It was not ever sitting in the dead end, and it could have been. He then parks the wrong way. Well, that could certainly alert neighbors to something's going on there. It is only after the vehicle stops and parks that the headlights go off. And we're at it right about 3 a.m. It's 47 seconds between that car stopping and then the car going back out. It is those 47 tragic seconds where Nilexia Alexander is shot and killed. That's quick. That goes only, please don't mistake me, to the aggravating factor in this case. The lights go back on. When the vehicle comes back on, they flick off for like a minute, and then they go back on again and the car leaves. In the video, remember, the street lights are on. So we're on a street. And if we're planning this heightened premeditation and carefully reflecting on it to kill Nilexia Alexander, why do we go to a residential neighborhood with the streetlights on it? You saw the streetlights in the video. Detective Whelan, the lead detective in this case, specifically told you this was in fact a residential neighborhood. Alan Wallace said the car lights even shined so brightly into his home, it disturbed him while he was studying for the bar exam. And he told you, the car's not stopped at the dead end, it is stopped in the, quote, middle of the street. So all of these things are things to think about when you are applying these facts to this aggravator of this heightened premeditation with substantial reflection and a cold, calculated, prearranged plan. This was not a desolate area. This was not an orange grove somewhere. This is not an area off the interstate. This is not a rural area. It was a residential neighborhood. You saw a map of the area yourselves. I believe it was State Exhibit 36. You could see it was a residential neighborhood with homes all around. Eric Walker told you aggravating factor that he intended to kill her, wanted to kill her, was going to kill her, and what he was mad about. None. And again, this is just the heightened premeditation we're talking about. And in fact, I want to go over what Mr. Creed said, Mr. Creed who's in the vehicle and is the witness to this tragic crime. Miss Alexander is in the car. Mr. Walker asks, "Are you having sex?" Miss Alexander says no. Robert Creed testified they were having an argument. That was his testimony, an argument, not a prearranged, carefully decided, heightened premeditation plan. Ronny got upset. Then Mr. Walker told her to get out of his vehicle because of the argument. Miss Fawcett has said that Ronny Walker told her to get out of the vehicle after she was shot. That is not the testimony. Use your own memory, but specifically it was you having sex, Miss Alexander, no. An argument was ensuing. Ronny was upset, and I'm just repeating the words of Mr. Creed. He told her to get out of the car, and then there was the first gunshot. So it was not after she was shot. The medical examiner, since Ms. Fawcett talked about the gunshot wounds, we don't know what shot is what. She talked about the stippling. She talked about a second gunshot wound, a third or fourth, for your finding for premeditation. Fully understand that. But when we don't have a sequence, we have no idea in what sequence we had these wounds. Placed close to her face, the one gunshot wound with the stippling, we don't know if she's already unconscious. I hate to even regress these facts, but it is important for the aggravator. After Nilexia Alexander gets out of the car, we know she is shot and killed. She ends up in that lot. But we don't know after that point, we don't have any evidence that he's saying, yeah, I came here to kill her. I'm gonna, we don't have that evidence for the heightened premeditation. They have not proven beyond a reasonable doubt that cold, calculated, and premeditated without pretense of moral or legal justification applies. Ms. Fawcett talked about things such as it was warm, so he must have worn the jacket for this plan, this careful plan. He wanted somebody to be with him. That's their theory, that's their argument. So, cold, calculated, and premeditated without pretense of moral or legal justification is the aggravator in the state of Florida. And I want you to pay special attention to the definitions. Cold. Cold means the murder was the product of calm and cool reflection. Think about that. Calculated means having a careful plan or prearranged design to commit murder. Think about that. The next paragraph is defining premeditation, which you have found that Mr. Walker did premeditatedly kill Nilexia Alexander. So you will get that definition again. Then it continues on for the aggravator in this case. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. The state has not proven that. Premeditation, yes, you have spoke out, but not a heightened premeditation, that there was calm and cool reflection or a careful plan or prearranged design to commit murder. There just wasn't any evidence of that. In fact, the evidence from Robert Creed was an argument had ensued, and he told her to get out of the car. And again, I'm not justifying even the argument, but I have to point these things out to you when the state is seeking that as an aggravating factor. The last paragraph will be the definition of a pretense of moral or legal justification. Is any claim of justification or excuse that insufficient to reduce the degree of murder nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. That aggravating factor alleged by the state of Florida has not been proven beyond and to the exclusion of a reasonable doubt. And remember, all of you must find that beyond a reasonable doubt unanimously to even consider it and go to the next step. So, that is the cold, calculated, and premeditated, and we have talked about their other aggravator. We would submit to you that they have not proven cold, calculated, and premeditated without pretense of moral or legal justification. And we ask that you mark on the verdict form no, because again, it has to be unanimous. Let's turn to something very briefly. I just want to remind you, and the judge is going to go ahead and remind when he reads you the instructions in just a little bit. We heard letters. We heard from Ashley Alexander, Nilexia's mom, her grandma, and I think it was the principal at the school. I told you an opening statement. Wonderful family. Very compelling. But we talked about this a lot in jury selection. We talked about it, I believe, in opening, and the judge will tell you. They had an absolute right to come into this courtroom and talk about the effect of Nilexia's death on them and the community. But you cannot consider that in any way, shape, or form as an aggravating factor, period. So please, the judge will tell you that. This will be, as we talked about in jury selection, your individual moral decision you are about to make here in a little bit. One of the mitigating circumstances is mercy. You can give mercy no matter what you find in a case. Keep in mind, Mr. Walker is severely punished for what he did to Miss Alexander with life in prison without parole. That's it. That's the bottom of it. He will never walk free again as a free man. We talked in jury selection about a couple of things that I want to go over. Then I'm going to go through some of the jury instructions with you and the mitigators and then the verdict form. But remember the law in the state of Florida during this phase. The law in the state of Florida never ever requires a death sentence, no matter your finding. Even if you had found 5 aggravators, if the state had 5, and no mitigation is presented, the law never requires you to come back and vote death. Each juror makes an individualized moral decision. You deliberate Go back there, you'll have the verdict forms, the instructions, talk about it. But you make your own individualized moral decision. Mitigation is any reason to choose life or to not choose the death penalty. This case is not the rarest of them. This case is not death penalty. This isn't a case where the aggravation is the most. You have the most aggravation and you have the least mitigation. But the judge will talk to you about the jury instructions and you'll have that back with you. You each get to decide what's mitigating. You can find something mitigating on your own that we did not even present to you. You may always lawfully vote for a life sentence because it is never required, as you know, and it does not matter what the findings are when you go back to that jury room. You may always lawfully vote life without the possibility of parole. You're never required to justify your vote, and all of you have the right to be treated with dignity and respect, and we were talking about that back in jury selection. And each of you finally has a legal duty to get your individualized moral decision onto that verdict form and into the courtroom. Because remember, it has to be unanimous if it in fact is going to be the death penalty. You all would have to say unanimous. One juror, 2 jurors, 3 jurors, but it has to be unanimous to seek the death penalty or to come back with a verdict of the death penalty. 1 juror with an individualized moral decision, 2, 3, but it has to be unanimous. All right, we'll go over a little bit about some really important parts of the jury instructions. The judge will, in fact, give you an instruction regarding the evidence you heard or the victim impact statements you heard from Nilexia's family, and he will specifically advise you, you must not consider this evidence as an aggravating factor. He will tell you how the state does have the burden of proof to prove the aggravating factor beyond and to the exclusion of all reasonable doubt, and it has to be found unanimously by the entire jury. He will give you the definition again of what reasonable doubt is, as he gave you in the first stage. And he will tell you that the finding of an aggravating factor must be unanimous. All of you must agree that that aggravating factor exists and has been proven beyond and to the exclusion of a reasonable doubt. Now, he will tell you that if at least one aggravating factor was proven beyond a reasonable doubt, one, as Ms. Fawcett said, and we talked about during jury selection, then Mr. Walker would be eligible. So they have to prove at least one aggravating factor unanimously beyond to the exclusion of a reasonable doubt. If you don't find the aggravating factor unanimously beyond a reasonable doubt, you let the court know that. And we're going to go through the steps because there's multiple steps you'll even see on the verdict form. So, if you unanimously find that one or both of the aggravating factors alleged by the state were proven beyond a reasonable doubt, and Mr. Walker is then eligible for the death penalty, then you go to the next step, and you have to make the additional findings. The next thing that you look at is going to be the mitigating circumstances. Just want to show some of them to you. The judge is going to read them all off in a little bit. Remember, you can find your own mitigation. Find your own. It does not have to be something that we even presented to you. But the mitigating circumstances, and it says among the ones you may consider. That's why you can come up and think of your own. Ms. Fawcett read each one of them off to you. But it's important. I'm going to try not to read each one. but she did read them all off to you. You will have them, and the judge is gonna have to read them off in a few minutes. But we certainly heard about his seizures, and we heard about his trips to the hospital, and we heard why those seizures started from Miss Hamilton. Because of the seizures, we heard about head injury, most importantly, a head injury where he fell from a 2-story apartment, she described in the projects, and hit his head. Those are mitigating circumstances to consider. The seizures most likely started because he was hospitalized with double pneumonia and bronchitis. His mom indicated that he was sick as a child and had to receive treatment and was in and out of hospitals. Ronny Walker never knew his biological father, and the witnesses have said this affected him, and it was consistent with all the witnesses. Ronny Walker was initially raised by his mother, a single parent. No one is up here alleging that Ronny Walker was abused or beat by anybody. Nobody ever said that. But he was abandoned by his father. Emma Hamilton was abandoned by Larry Walker, and those are things you can consider, that Emma Hamilton did everything she possibly could, even trying to keep her kids out of the system by giving them to Gloria, and we will get with Gloria in a minute. But he was initially raised by his mother, a single parent who had to do 2 jobs, and a mother who suffered from bipolar disorder and schizophrenia while raising him. Ronny Walker, you heard evidence from everybody. He grew up in the projects, and there was drug dealing and violence. You heard that from Emma Hamilton. You heard that from Davis George. Davis George presented you, that's Ronny Walker's cousin, a compelling story about 2 different worlds. It was a completely different world where Davis George, Ronny Walker's cousin, lived. His children are now successful. He's successful. Ronny Walker always wanted to be over there. In fact, you heard testimony that Ronny wanted to even live over there in the good part of town, on the other side of the tracks, as Davis told you. He wanted to go to school over there, where it was better. And then we heard on the mother's side of Ronny Walker's family, on the other side of the tracks, we heard about several incarcerations and family members imprisoned. Ronny Walker's guardian sold drugs while raising him. Emma Hamilton told you that. Gloria Mason, she testified, and her husband or her significant other were raising Ronny Walker, as you heard just this morning, starting at about the age of 10, because Emma Hamilton did everything she can to keep those kids out of the system and keep HRS away, and that is now Department of Children and Families. But Gloria and her husband or her significant other were selling drugs from that home. And who was in that home? Ronny Walker. His brothers, Antoine is now in prison, and Nikisha. After health and rehabilitative services were involved, Ronny Walker's mother had to give Ronny Walker and some of his siblings to his sister to raise. You heard Emma Hamilton testify that on occasions, Gloria would in fact keep Ronny from her. Yes, she visited him, but she did tell you there were conflicts, and there were times when Gloria was forbidding Emma Hamilton to even see Ronny. Ronny Walker's family, undisputed, you have heard, was torn apart when Ronny was very young, 10 years of age. We know his sister Paulette, number 12, was sent to live with her father, did not return to the family till the age of 10. So that's going to be a little bit earlier, but that's torn apart. At 3 years old, Tangi Johnson was taken from the family by her father. You heard from Tangi, and she told you the story of the Ancestry.com. Ronny Walker did not get to reunite with Tangi Johnson until he was incarcerated on this case in 22. The whereabouts of his brother, Mr. Stallworth, are unknown, and his brother, Antoine, so they're both Stallworths. Antoine is in prison, you heard. Wrong side of the tracks, as Mr. George told you. That family was torn apart, and remember the testimony of Tangi Johnson. She had indicated that When she reunited finally with Ronny, who she went to visit in jail pending this case, he remembered about when they were 3 and 4 years of old. His memory is her in a little yellow dress with a yellow bow. Do you think that she made that up? No. No. His family was torn apart, and there's been no evidence to the contrary. You have the school records. You can see, as we brought out in the evidence, that Ronny Walker attended multiple schools between 1984 and 1989. His last school was Ballast Point Exceptional Center. The school records in evidence reflect only up to the 6th grade for Ronny Walker. Remember, I had talked to some witnesses about learning disabilities, stuttering, being slow. Ronny Walker's Hillsborough County school records verify he was found eligible, placed, and served as severely emotionally disturbed, SED, at the age of 9. And that's right in the school records, which you'll have back there with you. They have been entered into evidence that he was found severely emotionally disturbed. Exceptional student information. At the age of 11, Ronny Walker was found eligible and placed as profoundly mentally handicapped. And that's also in the school records. Code 2150, and you have the sheet which shows 2150, profoundly mentally handicapped. That's at the age of 11. 11 years old. He's with Gloria at that time. 11 years old, so that's about 13 or so years before the tragic death of Elaine Caldwell. So you'll have all the records, and you can look at those. Ronny Walker has 3 children. You heard about the children, Ronell Walker, Paris Booker, and Ron J. Walker. You heard about Ronny Walker's son being murdered by gunfire in 2021, and that is approximately 1 year prior to the tragic death of Nilexia Alexander. You also heard that it greatly affected him, and he would frequently visit Ronell's grave, and you saw photographs of that, Ronny Walker at his son's gravesite. Ronny Walker's maternal grandmother, Thelma, died around that time as well, and Ronny Walker had been close with her. So in 2021, a year before this, he suffered the loss of his grandmother and his son being murdered. His son, Ron J. Walker, is currently in prison. Again, it's important for the wrong side of the tracks that we've talked about when it came to Ronny Walker and Davis George. Ronny is supported by family members, cousins, aunts and uncles, his mother, and you've heard testimony about that. You also heard that he offers support and encouragement to family members. You heard that from Lisa, who has his son, and you heard that testimony as well from Tangi Johnson. They would talk on the phone, and he would give words of encouragement to Tangi's son, and he would give words of encouragement to his son with Yisa. Now, you can consider everything, and the judge is going to give you a definition again of what mitigating circumstances can be. Anything, and it's anything as well from the guilt phase. And you can consider these things as mitigating circumstances. The testimony in the first stage by his employer, if you remember, that he was working at the time, and he was a good worker and did everything asked of him. This is at the car dealership that you heard about. He was cooperative with officers from the Tampa Police Department. You heard that from Detective Whelan and Detective Sackrider, and spoke with them for a lengthy period of time. These are things you can consider. He consented to a search of his vehicle. They get a search warrant, but he consented to the search of the vehicle prior, and then the officers got a search warrant after that. He volunteered his cell phone to officers during this investigation. Ms. Fawcett pointed out it may be a different cell phone, but who knows what was on that cell phone. He volunteered it to the officers. He consented to a buccal swab in this case for DNA. And you remember how the DNA was important in this case, right? In the car? He consented to that buccal swab being taken so it could be compared for DNA. He exhibited appropriate courtroom behavior during this trial. You are allowed to consider that. Remember, anything is a mitigating circumstance, and you can find your own. I've talked about this already. This is the prior violent felony convictions were the result of a plea bargain offered by the state of Florida. And it was in 2003, a single incident, because there's 2 judgment and sentences, and the judge lets you know one incident that he pled guilty to, took responsibility for, and it was about 22 years ago. He was 25 years old at that time that he pled guilty and took responsibility for that tragic event. Raymond Lee, and I talked about this earlier, talked about how he did not point a gun at Elaine Caldwell and shoot her intentionally. There was a struggle for the gun. Again, not excusing the behavior of being in someone's home, but that is mitigating for you to consider. He did not intend to shoot and kill anybody. Now, existence of any other factors in Ronny Walker's character, background, or life, or the circumstances of the offense that would mitigate against imposition of the death penalty. And that's where the stuff from the first phase comes in, right here, circumstances of the offense, but the existence of any other factors. And it could be something I'm not even presenting to you, it's something you think of. 34, Ronny Walker, if convicted as trial, will never be eligible for parole. You have assured that. He will never walk as a free man again and will die in Florida State Prison. It is just a matter of whose hands. And Ronny Walker is worthy of mercy. You are allowed to extend mercy. We talked about that in jury selection. So those are mitigating circumstances presented to you. You can feel that the aggravating factors even outweigh those and still come back telling the judge to sentence Mr. Walker to the life without parole. The judge will tell you, and we talked about this again in jury selection, regardless of the results of each individual's juror weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine the defendant should be sentenced to death. Law is always, life in prison without parole is always legal in Florida. So that's our first step. We have looked at the aggravating factors. Are they proved beyond a reasonable doubt? And that has to be unanimous. If you find one proven unanimously, you go to the mitigating circumstances. Those do not have to be unanimous. You can find your own. You do not all have to unanimously agree that one exists, unlike the aggravating factors. Please remember again, mitigating circumstances, the testimony, me showing you some things about the prior violent felonies or talking about what I think what we submit negates, cold calculated and premeditated. We're not excusing any behavior by Ronny Walker. Please, please remember that. Now, once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat, and this is what the judge is going to tell you, to repeat what I have said, if your verdict is that the defendant should be sentenced to death, and this is where we have all these steps you're going to see on the verdict form in just a minute, your finding that each aggravating factor exists must be unanimous. Now there's two, you don't have to find both of them for him to be eligible, but the findings must be unanimous beyond a reasonable doubt. So that's number one, that's the first step. So is he eligible? That's the next step. Then he will tell you, You're finding that the aggravating factors are sufficient to impose death must be unanimous. So now we're at another step that it must be unanimously decided by you that the aggravating factors are sufficient. So we had aggravating factors, eligibility for the death penalty if one is shown beyond a reasonable doubt. Then a finding that aggravating factors must be unanimous. Are they even sufficient to impose death? You're finding that the aggravating factors found to exist outweighing the established mitigating circumstances must also be unanimous. A lot of steps you're going to have to go through on the verdict form. And your decision to impose a sentence of death must be unanimous. Every step in there has to be unanimous, every step. The judge will give you the form. We're going to look at that in just a minute before I sit down. He will also give you some other instructions that you have heard similar instructions during the first phase of the trial. What I want to do now is show you the verdict form. It's the form the judge is going to give you in just a little bit for you to make your individual moral decision. And the judge is going to read this to you, and you'll get a copy of it for the findings to be listed out. So again, what's the first thing we're looking at? We're looking at the aggravating factors. 2 of them the state have alleged. You need to determine whether they have been proven beyond a reasonable doubt unanimously. It must be unanimous. That means each one of you to find cold calculated and premeditated without pretense of moral or legal justification must be unanimous for you to return that aggravator. And then the judge has both of them on here on the verdict form, and you would check off yes or no for the 2 aggravating factors. Again, has to be unanimous. Then, if your answer yes to at least one of the aggravating factors listed, please proceed to section B. If you answered no to every aggravating factor listed, do not proceed to section B. Ronny Walker is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. That's the eligibility, that one aggravating factor unanimously beyond a reasonable doubt. So that's going to be the first thing. Then we go to the sufficiency stage. Subparagraph B. We move on if you find aggravating factors unanimously beyond a reasonable doubt. We go to the sufficiency stage. Sufficiency of the aggravating factors as to count 1. Reviewing the aggravating factors that are unanimously found to be established beyond a reasonable doubt, section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. So that's going to be your next step. Ags, eligibility, are they sufficient? Unanimous, 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 unanimous. So if you say yes, you're going to keep going. If you answer no, that the aggravating factors are not sufficient to warrant a possible sentence of death, your deliberations are done. They're done if you didn't find any aggravating factors beyond a reasonable doubt unanimously. But when you get past eligibility with that and go to sufficiency, if you vote no, your deliberations are over and it will be life in prison without the possibility of parole, and just one of you in your individual moral decision can say life without parole. If you're continuing on because you have found the aggravating factors sufficient to warrant a possible sentence of death, then you're going to go and look at the mitigating circumstances. And the judge has told you in the instructions they do not need to be unanimous. And he'll give you the definition as I and Ms. Fawcett read off to you all the mitigating circumstances. And you'll answer this question as well. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence, and you'll mark off yes and no. But regardless of your findings there, you always proceed Regardless of your findings here with mitigating circumstances, you're always going to proceed now to D. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section A, outweigh the mitigating circumstances established, Section C. So it walks you through it. So now we're at the point, having to found all these things unanimously, we are now at the point that the aggravating factors that have been proven unanimously beyond a reasonable doubt, and the aggravating factors that have been found sufficiently to warrant a possible sentence of death, and you've gone past mitigating circumstances, now you must find to return the death sentence for Mr. Walker unanimously, that the aggravating factors outweigh the mitigating circumstances. If you find unanimously that the aggravating factors were proven beyond a reasonable doubt and outweigh the mitigating circumstances as to count 1 in Section C, so it always takes you back, you're going to check yes or no. If you answered yes, you go to the next step. If you answered yes to Section D, the aggravating factors unanimously outweighed the mitigating circumstances, please proceed to Section E. Here's your last step. If you answered no to Section D, that the aggravating factors did not unanimously outweigh the mitigating circumstances, your job is done. Ronny Walker will be sentenced by Judge Fuson to life without the possibility of parole. So we have all these steps in there that warrant you saying life without the possibility of parole, because it all has to be unanimous to go the opposite way. And then finally, subsection E, jury verdict, your actual final verdict. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factors are sufficient to warrant a sentence of death, Section B, and remember in Section B it has to be unanimous, and the aggravating factors outweigh the mitigating circumstances, and we of course just saw before that that has to be unanimous. All these steps would have to be unanimous. One aggravating factor established beyond a reasonable doubt. Aggravating factors unanimously are sufficient to impose a possible sentence. And the aggravating factors, you would all have to agree unanimously, outweigh the mitigating circumstances. Your final step, no matter what your findings are there, right? Your final step is to tell Judge Fuson what your verdict is. Life without the possibility of parole or the death sentence. And you still, no matter what you found prior, no matter what, you could find that those aggravating factors outweigh unanimously every mitigating circumstances in this case. You can do that. We've talked about that in jury selection, and it's in the instructions. You can find that and still give a verdict of life without the possibility of parole, because it is never mandatory to come back with your steps for the death penalty, even at this last Section E. That was the paragraph the judge is going to read you a little bit, and I read to you about regardless of your findings as to the aggravating factors and the mitigating circumstances, the law neither compels or requires you to come back and impose the death penalty. So you'll do yes or no. If your vote to impose death is less than unanimous, all these levels and then the actual vote, as you know, the trial court shall impose a sentence of life without the possibility of parole. So you'll have the verdict form, go through all those steps. And I've went through them enough, and you will get them again from the judge, and Ms. Fawcett talked about the steps as well. It's just important to remember that they all have to be unanimous, except mitigating circumstances, for you to ever come back and say the death penalty. And you never, ever, ever, no matter what, have to say the death penalty. So, if you simply see even a small spark of humanity in Mr. Walker, even if no one else sees it, you can give it the weight of life. And that is what we are asking Ms. Dunker, Ms. Bradley, on behalf of Ronny Walker and myself, to sentence him to life without the possibility of parole. And we thank you.
And members of the jury, you've heard all the evidence and the argument of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments. Number one, life imprisonment without the possibility of parole or death. In making your decision, you must first unanimously decide whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of the crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1. Ronny Walker was previously convicted of a felony involving the use or threat of violence to another person. The crimes of manslaughter with a weapon, robbery with a firearm, and burglary of a dwelling with assault or battery are felonies involving the use or threat of violence to another person. 2. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Further evidence about the impact of this murder on the family and friends of Nilexia Alexander. This evidence was presented to show the victim's uniqueness as an individual and the result of loss by Nilexia Alexander's death. However, you must not consider this evidence as an aggravating factor. As explained before, the presentation of evidence, as explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, after carefully considering, comparing, and weighing the evidence, weighing all the evidence, you do not have an abiding conviction that the aggravating factors exist, or, if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, the conflict in the evidence, or lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided with a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find that each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty. and your verdict must be for a sentence of life imprisonment without the possibility of parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment, imprisonment without the possibility of parole, or death. If you do unanimously find the existence of at least one aggravating factor, and that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. If it is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means that the evidence more likely than not tends to establish the existence of a mitigating circumstance. If you determine by a greater weight of the evidence that a mitigating circumstances exist, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to impose. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1. Ronny Walker suffered from a seizure disorder from birth, was placed on medication, and at times had to go to the hospital because of seizures. 2. Because of his seizures, Ronny Walker suffered head injuries as a child. 3. Ronny Walker was hospitalized with double pneumonia and bronchitis at the age of 6 months. 4. Ronny Walker was sick as a child and received treatment at USF Health. 5. Ronny Walker never knew his biological father, and the witnesses have said this affected him. 6. Ronny Walker was initially raised by his mother, a single parent. 7. Ronny Walker's mother suffers from mental illness, bipolar disorder, and schizophrenia, and a severe drug addiction while he was growing up. 8. Ronny Walker grew up in the projects where he witnessed drug dealing and violence. 9. Ronny Walker's guardian sold drugs while raising him. 10. After Health and Rehabilitative Services, HRS, involvement, Ronny Walker's mother had to give Ronny Walker and some of his siblings to her sister Gloria Mason to raise. 11. On many occasions, Gloria Mason would prohibit Emma Hamilton from seeing Ronny Walker. 12. Ronny Walker's family was torn apart when he was very young. Ronny Walker's sister, Paula Hardy, was sent to live with her father and did not return to the family until the age of 10. At 3 years old, his sister, Tangi Johnson, was taken away from the family by her father. Ronny Walker did not get to reunite with Tangi Johnson until 2022. The whereabouts of Ronny Walker's brother, John Stallworth, are unknown, and his brother, Antoine Stallworth, is in prison. 13. Ronny Walker attended 5 different schools between August of 1984 and September of 1989, at which time he enrolled in his last school, Ballast Point Exceptional Center, until March 1990. 14. The school records and evidence reflect up to the 6th grade. 15. Ronny Walker's Hillsborough County school records verify he was found eligible and placed and served as a severely emotionally disturbed SED at the age of 9. 16. At the age of 11, Ronny Walker was found eligible and placed as a profoundly mentally handicapped. 17. Ronny Walker had 3 children: Ronell Walker, Paris Booker, and Ronjaz Walker. 18. Ronny Walker's son, Ronell Walker, was murdered in 2021, approximately a year prior to this incident. 19. Ronny Walker was greatly affected by his son Ronell Walker's death and would frequently visit his grave. 20. Ronny Walker's maternal grandmother died around the time that Ronny Walker's son was murdered, and her death affected him. 21. Ronny Walker's son, Ronjaze Walker, is currently in prison. 22. Ronny Walker is supported by his mother, his siblings, cousins, and additional family members. 23, Ronny Walker offers support and encouragement to family members. 24, Ronny Walker was employed at the time of his arrest, and according to his supervisor, in the guilt phase of the trial, was a good worker and did many different tasks asked of him. 25, Ronny Walker was cooperative with officers from the Tampa Police Department in this case and voluntarily spoke to them for a lengthy period of time. 26, Ronny Walker consented to a search of his vehicle prior to the officers procuring a search warrant. 27, Ronny Walker volunteered his cell phone to officers during this investigation. 28, Ronny Walker consented to a buccal swab in this case. 29, Ronny Walker exhibited appropriate courtroom behavior during his trial. 30, Ronny Walker's prior violent felony convictions were the result of a plea bargain offered by the state of Florida. The offense occurred on October 23, 2003, and all three convictions resulted from a single incident almost 22 years ago. 31, Ronny Walker was 25 years old at the time of the prior felony convictions for which he pled guilty to. 32, according to testimony from Raymond Lee regarding Ronny Walker's prior violent felony of manslaughter, there was a struggle for the gun. When it went off, Ronny Walker did not intend to shoot and kill Elaine Caldwell. 33, the existence of any other factors in Ronny Walker's character, background, or life, or the circumstances of the offense that would mitigate against the possibility of the death penalty. 34, Ronny Walker, if convicted at trial as charged, will never be eligible for parole and will die in Florida State Prison. 35, Ronny Walker is worthy of mercy. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and the established mitigating circumstances that have been presented to you during these proceedings. The next step in this process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or a mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is given to a particular factor or circumstance. Regardless of the results of each juror's individual weighting process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous, and your decision to impose a sentence of death must be unanimous. You will be provided with a form to reflect your findings and decisions regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that a jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some of the things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony and evidence in the case? Had the witness been offered or received any money or preferred treatment or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? Has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than any of the other witnesses. It's entirely proper for a lawyer to talk to the witnesses about what testimony the witness would give if called to the courtroom. Witnesses should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be considered that the defendant did or did not take the witness stand to give testimony in the case. I'm going to give you some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your decision will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision. Your decisions must be based only on the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Your decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Remember that the lawyers are not on trial. Your feelings about them should not influence your decision. Your decision should not be influenced by any feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained within these instructions. In a few moments, you'll be taken back to the jury room by the bailiffs. When you've reached a decision in conformity with these instructions, the appropriate forms should be signed and dated by your foreperson. During deliberations, jurors must communicate about this case only with one another and only when all jurors are present in the jury room. You're not to communicate with any person outside of the jury in this case, and you must not talk about this case in person or through the use of a telephone, writing, electronic communications, such as blogging, Twitter, email, texting, text messaging, or any other means. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring those phones or any of those types of electronic devices into the jury room. Please kindly leave these devices on your seats where they'll be guarded by the bailiff while you deliberate. Do not contact anyone to assist during your deliberations. These communication rules apply until I discharge you at the end of the case. And if you become aware of any of these violations of these instructions or any other instructions that I've given in this case, you must tell me by giving a note to one of the bailiffs. During this trial, items were received into evidence as exhibits. You may examine whatever evidence you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. Also, the jury form will be sent back to you, and I'm going to go over that with you real quick. We, the jury, find as follows as to Ronny Walker in this case. A, aggravating factors as to count 1. We, the jury, find the state has established beyond a reasonable doubt the existence of an aggravating factor that Ronny Walker was previously convicted of a felony involving the use of threat of violence to another person. Check yes or no. 2, we, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder was cold, calculated, and premeditated without pretense of moral or legal justification. Check only 1, yes or no. If you answer yes to at least one of the aggravating factors listed, please proceed to Section B. If you answer no to every aggravating factor listed, do not proceed to Section B. Ronny Walker is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. Section B reads, the sufficiency of the aggravating factors is to count 1. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant the possibility of a sentence of death. Check yes or no. If you check yes to Section B, provide to Section C. If you answer no to Section B, then do not proceed to section C. Ronny Walker will be sentenced to life in prison without the possibility of parole. Section C, mitigating circumstances. One or more individual jurors may find that one or more mitigating circumstances was established by the greater weight of the evidence. Check yes or no. Then proceed to section D, regardless of your finding in C. So whatever you check, yes or no, you then move on to section D. D, eligibility for the death penalty for count 1. We, the jury, unanimously find that the aggravating factors were proven beyond a reasonable doubt in section A, outweigh the mitigating circumstances in section C above as to count 1. Check yes or no. If you answered yes to section D, please proceed to section E. If you answer no to section D, do not proceed. Ronny Walker will be sentenced to life in prison without the possibility of parole. E, jury verdict as to the death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, section A. That the aggravating factors are sufficient to warrant a sentence of death, section B. And the aggravating factors outweigh the mitigating circumstances, section D. We, the jury, unanimously find that Ronny Walker should be sentenced to death. Yes or no, check only one. If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. Then you sign the date that you made up your mind. It's also, again, the foreperson's signature and their printing of their name is required on this document as well. I cannot participate in your deliberations in any way. Please disregard anything that I may have said or done to make you think that I preferred one decision over another. If you need to communicate with me, send a note through the bailiff, signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I'll answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have agreed to live by the Constitution and the law. No juror has a right to violate the rules we all share. Now, jurors 13, 14, and 15, once again, you have provided an invaluable service, and I would ask that you remain behind while the other members of the jury are released to the jury room for deliberation.
All rise. Please leave your cell phones and smartwatches again on your seats. You can take any notes you wish to take.
Couldn't find that word. Jury's left, y'all may be seated. I want to thank you for your service and putting up with this process, and it was important. I'm going to release you now from your service. You're free to stay if you like, ask questions, or you can go home and go about your normal lives, whatever you choose. Thank you. Officially, yeah.
Well, no, but please.
We'll get one of these tickets on.
All rise.
There's a courtroom, maybe 2 hours.